10 o'clock, Tuesday, the 25th of April, 2023, and the beginning of our inquiry session for the Beech Way, Dalgety Bay CPO, proposed by Fife Council. Before I start, can I just have a quick show of hands or thumbs just to show that you can all hear me? Thanks very much. Because there has been an objection to the order and that objection hasn't been withdrawn, this inquiry is being held in accordance with the compulsory purchase by public authorities, Inquiries Procedures Scotland Rules 1998. My name is Tammy Swift-Adams. I'm a reporter with the Scottish Government Division of Planning Environmental Appeals. I'm the lead reporter for this case. I and my colleague Chris Warren, who is also on the call,
Morning,
have been appointed by the Scottish ministers to consider the proposed order and the objection to it, to hold this public inquiry and prepare a report to ministers setting out findings of fact and making a recommendation as to whether or not the order should be made. And it's the ministers themselves that will take the final decision. Our colleague Lucy Wakeham, who you met when you came into the meeting, will stay online with us today as well and manage technical matters for us. A reminder that as is usually the case these days, the recording's being made of the session. So by participating today, you're agreeing to that recording and to it being used for training purposes and kept as a public archive in the future, an archive which is made available to the public. Throughout the course of today, could you please keep your videos on at all times, but mute your microphones when you're not speaking. A couple of other housekeeping points. Firstly, just make sure mobile phones are off or will be on silent all day. The second is the fire alarm, which we've already dealt with. So I'll move on to introductions. Thanks very much for confirming in advance who was going to participate today and the order, the running order for the different witnesses. But I'd be grateful if you could now just put that on the record for the benefit of the meeting note. So can I start with Fife Council as the acquiring authority? Could you confirm who's going to be appearing for you in the inquiry and the running order of those witnesses?
Thank you, ma'am. Well, first of all, to introduce myself, my name is Chris Devlin. I'm a director in the Planning and Environment team at the law firm Anderson Strathern, and I'm representing the council in respect of this inquiry. The first witness that the council is calling is Mary Stewart. She's the service manager, major business and customer service planning services of the council. She'll be speaking to planning policy matters. The second witness is Andrew Riley of Andrew Riley Associates Limited, speaking to market demand in terms of class 4, 5 and or 6 uses at this particular location of the site. The third witness will be Ronald Hare. He is the Property Investment and Development Manager, Economic Development of the Council. He'll be speaking in terms of the requirement, need and justification for the CPO. And the fourth witness is Chris McMenemy, Property Planning Research and Information Coordinator of the Council, speaking to matters of employment, land availability at this location and more widely. And I propose that they would go in that order.
Okay, thank you very much. And you said you've got someone observing with you as well. Is that?
Yeah, we have two further in the room observing. Sheila Roger, who is a solicitor to the council, and Anne Rennie, who works with Ronald Hare in the economic team. But they will not be participating in the inquiry in any shape or form.
Thank you very much for that. And could I have the same information from the statutory objectors, please?
Good morning, madam. Everyone, my name is Neil Collar. I'm the head of planning law at Brodie's LLP Solicitors, instructed by the landowner and objector, and I'm accompanied in the room by Graham Stewart, who will be giving evidence.
Great, thanks very much. So a brief bit of background information before we get started. I held a virtual pre-inquiry meeting on the 14th of February 2023. I think several of you were participants in that. The participants there considered the process that should be adopted for this inquiry. There's a note of that meeting available on the DPEA website. It was agreed that we would have an inquiry session to consider two matters. Firstly, the requirement for the order, and secondly, the development plan and wider policy justification for the order for the scheme. The inquiry is scheduled to take place over the course of today and tomorrow. We've got Thursday in reserve if we need it, but I think that the mutual aim and expectation is that we will get finished tomorrow. We're proposing to sit until about 4:30 today, take some breaks at appropriate points. I haven't scheduled those, but we'll take a lunch break as well as a shorter mid-morning and mid-afternoon break. And if people feel they need a break at a particular point, you're welcome to flag that. In terms of resuming tomorrow, I propose we start a bit earlier at 9:30 if that suits people. We can confirm that again at the end of the session today. Today, the inquiry authority is going to start presenting its evidence first. And when we've heard from all those witnesses, we'll move on to the statutory objector. Parties have agreed beforehand that precognitions won't be read out. So that's fine. If there are small extracts people do want to refer to, that's no problem at all. Each witness will start with evidence in chief that should be combined to relevant points arising since the precognitions were lodged. And then each witness will then be subject to cross-examination. I or Mr. Warren might ask questions as well, and we may do that as interjections during the cross-examination rather than always waiting for the end of that. It'll just depend what makes sense in the flow of the conversations. Try to avoid irrelevant or repetitious cross-examination if you can, and if we need to, we'll interject if we think there's a line of conversation that isn't particularly going to help the inquiry, or if we want to just check where people are trying to get to, if a line of questioning's taken a long time. There'll be a chance for re-examination of each witness by their representative at the end as well, if there are additional questions that have arisen from the cross-examination. Although the session's being recorded, Mr. Warren and I will both be taking notes throughout, so I might at some point need to ask you just to pause while I capture a point or to slow down if I'm struggling to keep up. We agreed at the pre-examination meeting that we wouldn't take closing statements within the inquiry session. They'll be submitted in writing afterwards. We'd provisionally agreed on the 5th of May for those. So again, we can agree at the end of the session whether that's still the appropriate date for those to be submitted. And I think that's all I have to say for now by way of introduction. Are there any questions from anybody on anything that I've said before we get started in earnest?
Ma'am, the only observation I would make at the moment is that on our screen, we're not able to see Mr. Collar and Mr. Stewart. The camera doesn't appear to be working. I don't know if that's just our screen or possibly.
Okay, so I can see their table. I can't. They're not actually on camera themselves. I can see Mr. Stewart's hand, I think.
That's interesting. I think we've all got different images then, because I can see everybody clearly. So I'm currently winning. I'm not sure what the solution is.
So, do you know if you're there? Do you know if there's anything that Mr. Devlin might be able to do to change his view of the objector? Maybe not there at the moment.
No, I'm here. If he goes to the view bar at the top of his screen, that might help. So if you click view and click gallery, that should bring everybody up.
It is currently on gallery, but I'll try gallery at top to see if that makes a difference. Unfortunately not.
Or try large gallery.
Unfortunately, that doesn't seem to be making a difference. The confusing thing for us here at the council is that we can see both reporters and Ms. Wakeham. Simply, the only party that we cannot see is actually Mr. Collar and his witness, which is very curious.
Can you see the sort of the circle for them, or a blank screen, or is it just as though they're not there?
Yes, ma'am. We can see the circle that has Mr. Collar's initials on it.
Are you able to turn the camera off and on again, Mr. Collar?
I'll just try that.
If it's as
Let's
simple,
see.
that might work.
Right, so that's it off. And that's it back on. Yeah.
Has that worked?
Yeah, we can now see everyone. Thank you very much.
Right, brilliant.
Thank you.
Thank you.
The only thing is, Madam, you said that you could sort of see the room but not really see us.
Yeah, I can see you both now. There's a wider view now.
Ah.
Yeah, I just sort of had the tabletop before, but it's wider now in the course of that conversation.
Great. Thanks.
Okay, so we can move on to the five council's evidence. So your first witness was Mary Stewart, you said. So just while Mary gets ready, Mr. Devlin, do you want to introduce matters to the council and then move on to your evidence in chief?
Thank you, ma'am. As you have set out, ma'am, the Fife Council seeks confirmation of the Fife Council Beech Way Dalgety Bay Compulsory Purchase Order 2022, and confirmation of the order will allow the council to acquire compulsorily all of those interests in that area of land extending to 1.32 hectares, or thereby site of the former Maxwell building at Hill End and Donnybristle Industrial Estate. For more than 20 years, the site has sat on the council's vacant and derelict land register. Council's aspiration for the site is that it shall, as part of the ongoing regeneration of the Hill End and Donnybristle Industrial Estate, be redeveloped for Class 4, 5 and or 6 uses. Should the order be confirmed by the ministers, this will enable remediation of the site in the first instance by the council in order to facilitate Class 4, 5 and or 6 redevelopment to come forward. Redevelopment would take a long vacant and derelict site and improve it. And the council's position is that doing so is consistent with the local development plan, which is Fife Plan 2017, and also Scotland's fourth national planning framework as the development plan. In Fife Plan, the site is safeguarded for Class 4, 5 and 6 uses, and therefore it is also submitted that it's in the interests of the proper planning of the area that the site is brought back into these uses. The first witness for the council is Mary Stewart. As I mentioned, she is the service manager, major business and customer service, planning services at the council. She is speaking to planning policy matters, and I don't actually propose to do any examination in chief arising as a result of recognitions that have been submitted in respect of Ms. Stewart. So happy to hand over to Mr. Collar to begin his cross-examination.
Okay, thanks very much. So over to you, Mr. Collar.
Thanks very much, and good morning, Ms. Stewart. For everyone's convenience, maybe if I can just ask or intimate that the documents I'm going to be mentioning in the cross-examination, certainly the first part, there's maybe one or two towards the end that we might come to. Firstly, the statement of reasons, which is document FC3, the Fife plan, which is FC6, and then your precognition. As I say, there are one or two others towards the end, but those are the main ones that I thought it would be useful to give everyone a chance just to have in front of them.
Thank you.
So if we start with the statement of reasons, which is document FC-03, and the very front page, the title of the order is set out. We see that it's the statement of reasons, and then there's mention of the Town and Country Planning Scotland Act 1997. So we can see from the front of the statement of reasons that the starting point is the Planning Act. Okay. And going into the statement of reasons, and unfortunately, the pages aren't numbered, but towards the end, we can see it's at the end of section 16, which is headed up list of documents, and it says any requests for information can be made to, and there's the contact details there for Anne Rennie, who we see as lead professional property investment and development, economic development, business and employability services. Given that she's there as the point of contact, would I be right in thinking that it's the council's economic development function that are promoting the CPO rather than the planning service?
Yes, it was promoted by our economic development service, who are closely linked to our planning service, and until probably about 2 years ago, we were all actually part of the same service within the council.
And then if we go backwards, as it were, in the order to section 8, and again, apologies, there's not a page number, so it's probably just easier that everyone finds section 8. So section 8's headed up planning position. There's a paragraph there on planning, and just to check, did you write that section or was it someone else in the council?
No, I did not write that section.
Yeah. And if we turn then to section 5, which is about the use of the Enabling Act, and this is really just setting the context for the issues that are at the number of the objection. Section 5 sets out the terms of section 189 of the Planning Act, and we can see there it says section 189 allows local authorities to purchase compulsorily any land which is suitable for and is required to secure the carrying out development, redevelopment or improvement and is required for a purpose which is necessary to achieve in the interests of the proper planning of an area where the land is situated. It's a bit of a mouthful. I feel as a lawyer I should apologise for something that a lawyer obviously produced in the drafting, but we can see there are a number of elements. Firstly, the land is to be suitable for, and then is required to secure the carrying out of development, etc. And then is required for a purpose which is necessary to achieve in the interest of the proper planning of an area. So we can see from that it's not enough that the site is suitable for. The legislation also requires us to consider if it is required for. So there are at least those two elements, aren't there?
Yes, that's correct.
Yeah, and I appreciate I'm using a lot of shorthand, but I just wanted to set that context. To put this into terms which you as a planner could discuss, I wanted to create a hypothetical planning policy because I think that might be an easier way of introducing the next questions. And this hypothetical planning policy says that development will only be permitted where it's necessary. So I emphasise this is purely hypothetical. So you would agree that in the terms of that hypothetical planning policy, it wouldn't be enough for a developer to show that the development is acceptable. They would need to show something more to satisfy that necessariness.
Yeah, I would agree with that.
And I'll come back to that hypothetical policy in a moment. In your precognition, probably in several places, but at paragraph 3.3, you say, in my view, the Council's proposals are entirely consistent with and supported by the development plan currently in place for Fife. And I will come back to the detail of that. When you say the proposals are consistent with, would it be fair to say that means the proposals are acceptable for planning purposes?
Yes, I think that's fair.
Yeah. Would you also accept that there's nothing in your evidence or in the development plan to show that the development proposals are necessary or required? What I'm really doing is I'm going back to there's a difference between acceptable on the one hand and necessary or required on the other.
I would accept that there's a difference between acceptable and necessary, but I wouldn't accept that there's nothing in the development plan to support the fact that the development is necessary. The development plan as it is now consists of NPF 4 and Fife plan, both of which have policy around brownfield land, the use of brownfield land. This site I would consider to be brownfield land. In terms of Fife plan policy, the policy 5 looks to secure employment uses, safeguard the site for employment uses. The site has not been in productive employment use for a considerable number of years. So I would contend that the development plan position supports the site being brought into employment use.
Well, I understand that it supports it. What is it in the development plan that shows bringing the site back into use is necessary or required.
If we look at NPF 9, which relates to brownfield land, seeks in terms of policy intent to encourage, promote and facilitate the reuse of brownfield, vacant and derelict land to help reduce the need for greenfield development. As I've stated, the site has been disused, derelict. I believe the original building which occupied the land was removed around 2013, and the site would therefore meet the definition of brownfield, vacant and derelict land. So that support is there in terms of NPF 9.
So your position is that because NPF 9 the policy intent to encourage, promote and facilitate reuse of brownfield, that is sufficient to make the council's proposal necessary or required?
Yeah, it's further in terms of how plan policy 5. The site forms part of an established employment area. And is not functioning in line with that use. I believe colleagues will lead evidence in terms of the impact of that on the wider employment, existing employment area. So in terms of supporting the development plan position to safeguard and promote employment use on an established employment site, I believe it is supported by 5 Plan Policy 5.
Well, I'll come back to Policy 5 because I've got a series of questions on that. Indeed, I might pick up an NPF 4 at some point. So I'll pick up on those later on. But on Policy 5, looking at the various elements, as a starting point, Policy 5 applies equally to all existing employment areas throughout the LDP area.
Yes.
Yeah. So it doesn't give any special weight to employment uses in Dalgety Bay. In other words, under Policy 5, there's no greater need in Dalgety Bay than anywhere else in the LDP area.
No, not in terms of Policy 5 and its application.
Yeah. And You've not referred in your evidence, your precognition or any of the other documents that have been lodged to any other provision in the LDP which gives a reason to prioritise Dalgety Bay.
No, I haven't.
And returning for a moment to the hypothetical planning policy, development only to be permitted where necessary. And we already had a bit of a discussion about it wouldn't be enough to show that the development is acceptable, so there's got to be some greater justification. And again, this is me just trying to put it into context. So, for example, a school could be necessary in this hypothetical example because pupils need to be accommodated in the locality.
I'm not understanding what you mean.
Well, I'm trying to explore possible meanings of necessary in my hypothetical planning policy. If you were the development management officer considering an application, if it was an application for a school, that could comply with the necessary criteria because a school would be proposed because of the need to accommodate pupils in the locality.
It could be demonstrated to be required or necessary because of the need for education. I don't see that that's any different from the need for people to have gainful employment.
Well, one difference is pupils normally are accommodated close to where they live. Having to bus them distance is generally something that is avoided, particularly at primary school level. But for employment uses, there's a concept of travel to work areas. So there's an acceptance that employees don't necessarily expect to work somewhere close to where they live. It's generally accepted that there will be an element of travel. Is that right?
Not necessarily. We are being encouraged to minimise the need to travel in line with the need to address climate change. So the focus from NPF4 particularly is on reducing the need to travel sustainably whenever possible, which draws down whatever that travel distance which is acceptable might be. I would say the expectation for employment is that it would occur for types of employment, particularly in classes 5 and 6, that they would be within an established employment area or a proposed new employment area, because they are types of employment which people do want to be at some distance and not impacting on the residential amenity they enjoy where they live, so that there is a balance of distance between home and work for those specific types of uses, which are the uses this established industrial area is designed mainly to accommodate.
Mm-hmm. Well, there's several parts to your evidence there that I want to explore further. Firstly, the council's case at this inquiry does mention the good transport links of this site as part of the justification, doesn't it?
Yes, and it does have good public transport links.
Okay, and the other part about encouraging or the need to reduce travel by other means, have the council provided any information to this inquiry on where existing workers on the estate travel from?
I don't believe we have.
No. So at the moment, the council are proposing to acquire the site for development without providing any information about what the travel patterns might be.
Because of stage councillor Act, council have provided evidence that their intent is to prepare the site for development. It would then be marketed for class 4, 5 and 6 use. So until such time as at least that initial marketing takes place, it's very difficult to predict. And as a planner, I wouldn't expect somebody to predict at this early stage of the development process.
Mm-hmm. And I entirely agree. It's way too early to make any sort of prediction about any of those aspects. Returning to my hypothetical planning policy about development only being permitted where it's necessary, if you were the officer assessing a planning application that was falling within that policy, would you be recommending permission be granted if the developer didn't show evidence of actual demand from potential occupiers?
I would see that as no different from a number of prospective developments. If I can use a similar example, we quite routinely deal with applications for large housing sites. It's quite apparent that when we receive the application, it's been submitted by a landowner, not a developer. I wouldn't expect the landowner to provide me with details of interested residential developers as part of the planning process.
Mm-hmm. But the hypothetical planning policy, the test is that the development is necessary. Is it your position that a development could be necessary in the absence of evidence of actual demand?
I think the balance would be, firstly, as part of a planning application, as a planning officer, I would consult with colleagues in economic development. I'm not an expert in market demand for industrial property. So firstly, I would rely on their advice. As part of our internal consultation process. In terms of the reuse of a derelict site, even getting to the initial stage where the site constraints are addressed and the site is actually ready for reuse. As a planner, I see that as a step forward from the current situation, and it removes an element of visual blight, if you like, from an important gateway into an industrial estate.
Well, the point I'm making is, again, going back to my hypothetical planning policy, which is saying development is only permitted where necessary. The experience of a lot of developers is that planning officers expect quite a high degree and amount of evidence to be convinced on policy compliance. And the point I was exploring here was a developer who applied under a policy which required evidence that the development was necessary. A developer would struggle to get a thumbs up from a planning officer if they couldn't show evidence of actual demand. Surely that's right. Surely a planning officer would be expecting a fairly weighty body of evidence to include evidence of actual demand to show that the development was necessary rather than just acceptable or suitable or desirable.
I think on balance, as a planning officer, I would take the views of the consultee over material provided by the developer. And as I've said, I would consult with economic development who have the expertise to advise on demand and necessity. They are dealing with demands, inquiries from businesses around Fife, and are probably in a better position to advise me than a developer. And any information that the developer did provide in terms of necessity, I would, seek advice from colleagues in economic development to verify, in any case, what I was being presented with.
Well, I'm going to take the point up with the other council witnesses, so move on. But staying with the issue of necessary, but just exploring a potentially different aspect. And again, this is a hypothetical, just to illustrate the context. Another reason why development might be necessary in a site is if there's access to resources that aren't readily available somewhere else. So for instance, a thermal power station project might need cooling water, which isn't necessarily available everywhere. Other uses might use an adjacent rail siding for freight. I'm sure we could come up with plenty of other reasons. The point I'm really making, there's nothing about this site which provides access to any special resources or special facilities, is there?
Nothing of that type. It does occupy a key position at the entrance to an industrial estate, however. So it has a level of prominence in terms of a business location.
How does that make the development necessary?
Doesn't make it necessary, but it makes it more likely to be in demand.
Well, does it though? Because this is the type of business, industrial, warehouse and distribution use. Those sorts of users aren't particularly looking for a prominent site, are they? They're just looking for a site that they can fit their development on.
What I'm advised is that they are looking for a site that is ready for development with the minimum of upfront costs in terms of services, dealing with contamination. And in some cases, yes, they do seek a prominent site. We've dealt with a number of inward investors, both Scottish and international, who are looking for prominent sites. Particularly, I can think of some of the distillery clients elsewhere in Fife who have particular requirements of a site, and I think this site would have some of those particular requirements, that it's near enough to the access to the site that important visitors to that business are not having to drive past or negotiate the way through a multitude of other industrial and business properties to find their business. So it has a prominence.
But you've acknowledged within your comments there that is for a fairly narrow class of users. If the site was developed for warehousing, which is one of the possibilities, the prominence of the site isn't an issue. The issue for warehousing is primarily accessibility to the transport network, isn't it?
Yes, and by being at the entrance to the industrial estate, it's also accessible.
It's not any more accessible than if it was slightly further in the industrial estate, though, is it? Well, to put it another way, because it might be a bit easier to answer, there is evidence before the inquiry of various other sites in the locality that have been developed, have secured users, are in negotiations, etc., etc. None of those sites are as prominent. So surely that shows evidence that there are plenty of users out there who don't necessarily need a prominent site.
You know, as a planner, I'm no expert in business, but having dealt with businesses through the planning process, the site finding requirements for businesses are so varied. But I can say that prominence is one of the things which we have on a number of occasions been asked to deliver in terms of certain types of businesses.
Well, and just to round off that point, there's no evidence before this inquiry of actual demand from an actual user that needs a prominent site, is there?
I wouldn't know that. I'm dealing with planning, not dealing with economic inquiries about expansions, etc. That would be for colleagues in economic development.
I'll be picking that up with them. On planning issues, I did say I might look at one or two other documents. If we can look at the industrial land review, but don't worry, it is an actual planning point within it. So that's document FC13. And if you turn to actually, I think it might be Mr. Riley's precognition rather than the actual. No, it is. Sorry, just give me a minute. What I've done is I've got the wrong document number. Right. Have you managed to get a copy of the Industrial Land Review, whatever document number it is? Yes. Sorry. Not being good. If you go to section 6, market constraints. Now, unfortunately, there's been a problem with the numbering. So there are two paragraphs, 613 and 614. It's the second 614 that I wanted to refer to. So it's at the bottom of the page. And it says, in Dalgety Bay, the intervention has been successful both in terms of land sales for industrial development and for redevelopment of starter units. There has also been sale of a proportion of the land to higher value alternate use residential, which has assisted in removing older stock at the east end of the estate. However, the change of use has ensured more pressure is created in industrial land supply in the area. I just wanted to ask you about the planning context there. Reference to the residential land, is that the site on Fulmer Way, which was formerly an industrial use and is allocated in the LDP for residential use?
That refers to the OCLI site, which was, I believe, granted on appeal.
It's maybe something I can clarify with Mr. Riley later on, but am I right in thinking that there's a planning application by Muir Homes for a site on Fulmer Way, which was formerly an industrial use, but is allocated for residential use in the LDP?
There's been a number of planning applications relating to that site.
So the point Mr. Riley
refused to do.
The point Mr. Riley's making is that part of the reason for the CPO site being necessary is because other stock within the estate has been allocated for residential use.
I don't think it's fair to say it was allocated for residential use. The site which has been referred to there was not allocated for residential use. However, it was granted permission for residential development on appeal. So that reduced the availability of industrial land. And I think that's the point that Mr. Riley is trying to make, but that's really a question for Mr. Riley to answer as part of participation in the process.
And I'll take that up with them, but the Muir Homes site that I then referred to on Fulmer Way, which you said is subject of a planning application, that is a site which was formerly part of the estate, but was allocated for residential use in the LDP.
It was allocated for residential use in the LDP. It wasn't put forward by the council for residential use as part of the LDP process. And the history of applications on that site and the number of refusals for planning permission for residential development could be seen as an indication of the problematic nature of residential use on that site.
Thank you for that. Moving on then to the topic of safeguarding. So I've finished with the industrial land review. And going back to the statement of reasons, and turning to section 2 of the statement of reasons, which is headed up purpose, and that's quite a long section. I particularly wanted to pick up with you the fourth paragraph. So that's over the page, as it were, and it's the paragraph starting industrial estates across Fife, if you've got that.
The statement of reasons, section 2, the fourth paragraph I have starts with the lack of site servicing.
That's the same in my copy.
1, 2, 3. It's maybe the way that we're counting. It's the paragraph above that I wanted to refer to. Industrial estates across Fife. It starts.
I don't have a paragraph that starts with that.
I don't know.
Well, if we start from section 2, purpose, The first paragraph starts, the order land occupies a strategically important location.
Yeah,
Yes.
And then the next paragraph, End and Donnybristle Industrial Estate.
yeah,
And then the subjects occupy a prominent location.
yeah,
Yeah.
And then industrial estates across Fife are subject to encroachment.
no, no. And then the next one in mine is the lack of site servicing of the subjects. Do you want to check? Have you got the online copy in case it's the page orders that's gone awry?
What's concerning me, Madam, is the statement of reasons that was served on my clients might not be the one that has been lodged before you.
Okay.
And possibly for the purposes of the question, maybe that isn't hugely significant, but it still does concern me that we seem to have two different versions.
Well, I'm working for the one that's been lodged with the DPEA, and I've checked online, and the paragraph that you're referring to doesn't appear there. That location in the copies that I've got, can't see it. Can't see it elsewhere either as a paragraph starter, so I don't think it's the document's out of order.
And would it be worth a short adjournment just for us to check that point here at the council? Don't really want to interfere with the evidence giving, but
Yeah, that's fine. I'm happy to take a short
break now.
take a short break for 5 minutes if that's, or a little bit longer if we want to resume at 10 past.
Shall we make it the actual break now? Have a little bit longer and then we can pick it.
Yeah, actually we would be due a break in a little while, so would people just like to take a slightly longer quarter of an hour break now and resume at 20 past? Is that okay?
Yes,
that would
thank
be
you.
And just remembering that the witness that's being examined shouldn't speak to their representative during the break. Okay, otherwise I'll see you back at 20 past. Hello, it's 20 past. Is everybody ready to resume?
We are still in the process of checking our files in respect of the apparent sort of different versions that are in circulation. Sheila Hodger, who's not participating in the inquiry, but who is a solicitor with the council, is off checking that point. I think I'd probably just want to leave it to a discussion between yourself and Mr. Collar in terms of whether or not we proceed at this point in time, or if some further time should be given to for us to check our files on that.
Okay, so Mr. Collar, would you be happy to carry on cross-examining the witness on the basis of the statement of reasons that is before the inquiry? Now, the council could perhaps do further checking when we're in the longer lunch break, or does the difference in the statement of reasons cause you problems in your line of questioning?
I'm very hesitant to slow the progress of business, but the particular issue I raised or wanted to raise is actually really quite fundamental, and I am therefore reluctant to progress this in the absence of clarification of the position. My slight concern here is that if the council have served on my clients a statement of reasons which isn't actually the statement of reasons they meant to serve, that could have very significant implications for the entire process. The alternative, obviously, is that the copy you have before you is the wrong copy, as it were, and that's less significant. So I think until we clarify that, because the particular issue I was going to ask about, from our perspective, seemed to be quite a key part of the council's case. But I now don't know whether or not it is actually part of the council's case.
Okay. And during the break, did you have a chance to have a look at the statement of reasons that has been lodged with the inquiry and see the extent to which there was a difference? Is it just that introductory sentence to a paragraph, or is there something more substantial that you were looking at that isn't in the statement that's before us?
On a quick look, there are 2 or 3 paragraphs which are different. The paragraph I wanted to discuss isn't there, and there's differences in other paragraphs. So without further examination, it's hard to draw a conclusion about how significant some of the changes are. But as I say, the particular paragraph I was going to mention seemed to relate to what we thought was quite a key issue of the council's case. So it could make a significant difference whether or not it is actually part of the statement of reasons or not.
Okay, and in terms of the remainder of your intended line of questioning, is there much of that that isn't dependent on the statement of reasons? Just wondering whether we could, once we do know which version is the intended version of the statement of reasons, we could come back to that.
Madam, yes, I could park that issue and pick up the rest of the cross-examination, and we could then regroup, as it were, and see where that left us.
Okay, so I'm happy to have a longer adjournment if that would help you just reorder your cross-examinations to account for that
We may have an answer.
issue.
It's a bit.
Unless
I just have 1 minute. I may be able to provide an answer if that's okay.
okay, I'll mute and come back at past. Then that's 4 minutes. So
Okay.
And then Mr. Collar, we'll come back to Mr. Collar after that. Just a reminder, you might want to, everybody might want cameras off while we're on adjournments. You don't have to, but you might prefer it. So I'll see you back at past.
Thank you, ma'am.
Again, where have we got to? Council. Okay, Mr. Devlin, have you got an update?
I can provide you with an update, ma'am, but I don't know if it necessarily explains the position as to what is available on the Directorate's website. The Council has presented me with an email from Sheila Roger to the Planning Decisions email address dated the 26th of August 2022. And the statement of reasons that was attached to that email is the version that was served on Mr. Collar's client, the landowner. So the paragraph at the top of page 2 of the substantive text that begins industrial estates across Fife are subject to encroachment.
Okay.
So if I'm being completely honest, at this particular juncture, we are slightly at a loss as to why there is a different version available to you, and also a different version available on the website for the dedicated website for this CPO matter. I checked the website earlier on this morning, and downloading the statement of reasons that's available dated on the website the 20th of September. That has the paragraph that begins the lack of site servicing as opposed to the paragraph industrial estates across Fife. So for the purposes of Mr. Collar's cross-examination, I do think that we can say that he is working with the correct version that was served on the landowner, and therefore, if I can put it this way, it is the lesser of the issue rather than the greater of the issues that is at hand here. It may be worth the council undertaking a bit more investigation as to exactly why a different version does appear on the council or on the Directorate's website. But based on the papers before me right now, the version of the statement of reasons that was served on Mr. Collar's client, and also the version that was initially sent to the Scottish ministers on the 26th of August, is that version that includes the text, industrial estates across Fife are subject to encroachment, etc., etc.
Okay. So what you're saying is that the correct statement of reasons, the objector did receive the correct statement of reasons, and it's the one that's on file is a different version.
That's my. It seems possibly, ma'am, that there are two versions that the Scottish ministers might have. We haven't got to the bottom of why that is the case yet. The version that was served on Mr. Collar's client is the version that he has in front of him. Fortunately, it's not.
But like me, I think it sounded like the version that your clients are working from within their own papers is the same version I've got, the one that's on the department website. Is that right? You didn't have the version.
That's correct in terms of the papers here, but we have printed off further copies of the version that was served, and so that can be presented to the witnesses right now for the purposes of cross-examination.
Okay. I'll just take a really brief just a minute break and just speak to Mr. Warren and come back with a suggestion. Hello. I think everybody can hear me. Okay, so what we propose is, obviously we need to have copies of the correct statement of reasons. We're happy to just accept that now and continue the inquiry once we've got that in front of us, if that's all right with other parties. So if that version is emailed to dpea@gov.scot now, our colleagues will be able to quickly give us a copy of that. And Mr. Warren and I are both happy to pick up that version now and work with that for the purposes of today's session. I think that would allow Mr. Collar to resume where he was.
My only concern about that, Madam, is yourself, Mr. Warren, in your preparation for today, have in effect been looking at the wrong document. And as a result, when you look at the right document, you might have different matters that you might want to raise with witnesses if those matters are not raised by me in cross-examination. What I would suggest, one of my colleagues has run an electronic comparison between the two documents. I've not actually had a chance to look at that myself, but I would suggest if that was also emailed to your office, that would mean that you could have a quick look and actually see the extent of the differences. As I say, I've not had a chance to look at it. Other than the particular point that I wanted to cross-examine on, which I will be cross-examining on as a result of the conversation we've just had. Other than that, I suspect the differences might be more cosmetic and refinement. As I say, I've not had a chance to look, and I'm just slightly hesitant. We should be proceeding without you having a chance, and likewise myself having a chance to just have a quick look at the extent of the differences.
Yeah, if I may. So I'm just a thought from me. I'd be content to proceed listening to evidence at this stage once we've got a copy in front of us. But my suggestion would be, if you complete your questioning, Mr. Collar, before lunch, if that's the case, we would then use the lunch break, of which we'll have an hour, which should hopefully give us sufficient time to be able to consider the differences, and that obviously that would then come before our questions. So if we've got different questions to ask as a consequence of the differences in the statement of reasons, that would give us the opportunity to have them ready, so we're not missing the chance to ask the right questions of the right evidence.
It sounds like a useful way of doing it. As I say, I need to have a quick look to make sure it doesn't change anything that I would be asking. But I think I can probably do that fairly quickly.
Okay. And I think I would suggest, tell me if you disagree, I would suggest just emailing the correct statement of reasons at the moment, if you haven't yourself looked at the difference document, because if I'm right, I think that both documents would then be before the inquiry and be published to the website. So I think maybe if that's not been looked at, it would be best just to send Mr. Warren and I a copy of the statement of reasons for now. You agree?
Be content with the comparison as well, to be honest. Yeah.
If you are, then it's fine. Okay, yeah. Send both copies. That's fine. We'll
Can I just ask the council whose email address it would be best to send it to so that they can see the comparison version too?
I was just about to make that point as well, Mr. Collar, so thank you very much. If you could please arrange for the comparison to be sent to my email address, which I think probably you'll have on file, or one of your colleagues will. and that I think will be sufficient for purposes of today. Thank you very much.
Email's quick, isn't it?
Okay, so we suggest we resume at 10 to. That should give enough time for the document to come through and for us to print it off. Okay. No dissent. Okay, well, let's see you back at 10 to. So Lauren and I are ready to resume as soon as the rest of you are. So we've got a copy now in front of us of the statement of reasons that comes through, comparative documents on its way through. So we're ready to start again. Mr. Collar, are you ready to resume?
I am, thank you, Madam. And just to confirm, on a quick look at the comparison document, I don't need any time to change cross-examination questions. That the other differences, as is suspected, are more minor. So it doesn't change anything in the questions I was going to ask, and I suspect it would probably be the same for yourself and Mr. Warren, that it doesn't change the content or anything else significantly. So I'm happy to proceed.
Okay, thanks very much. I'll hand back to you then to review your explanation.
Thank you. So, Ms. Stewart, hopefully you're now looking at a copy of the statement of reasons, which is the same as the one I'm looking at, and to confirm the particular paragraph, it's in the section 2 purpose, and the fourth paragraph. So it's actually towards the top of the second page within that section, and it says industrial estates across Fife are subject to encroachment from alternative and higher value uses such as retail and leisure. You accept that the council, as planning authority, have power to refuse planning permission for retail use on this site? Yeah. So in that paragraph in the statement of reasons, if we go now to the final sentence, so same paragraph, final sentence, it says the proposed acquisition by the council would therefore safeguard the retention of this site for future business use, particularly having regard to the current owner's aspiration to secure a non-compliant use for the site. Given that the council can refuse planning permission for non-compliant uses, this can't be a reason for the CPO being necessary, can it?
The council has the power to refuse planning permission for retail use on the site, and that such a refusal, in my view, would be supported by development plan policy, and that has been expressed by the council as planning authority to the owner of the site through pre-application advice, which I believe is included in the papers. I don't think I would describe it as a necessity in terms of safeguarding the site for future business or employment use. Ultimately, it would ensure that it was safeguarded for employment use.
Moving on then, staying within the statement of reasons, going to the beginning, as it were, and it's the first part headed up introduction, and we see there opening sentence, this is the statement of reasons, etc. The land referred to within the order is referred to as the order land. And then it says the order has been made by the council to authorise the compulsory purchase of the order land for the purposes of site remediation and servicing with the view to selling individual serviced employment sites. None of that is about safeguarding, is it? It goes way beyond safeguarding.
Safeguarding is about ensuring the site remains in employment use. I would read that sentence as taking the site to a point where it can be brought back into productive use.
Well, that's really the point I was going on to make, that if we look at the 5 Plan Policy 5, and I suppose if we can take this step by step, Policy 5 says all existing employment areas and those allocated in this plan, and just so that we're on the same page with this, this isn't a site which is actually allocated, is it? It falls within Policy 5 because it's an existing employment area.
The site which was within an existing employment area, it would never have been allocated for employment use.
Yeah. So it's subject to the policy because of its existingness, as it were.
Yes.
Yeah, I just wanted to make sure I was understanding that correctly. So the policy then goes on, will be safeguarded for continued industrial and business use. There's nothing within that requires it to be brought forward for development. It just says safeguarded. Safeguarding is about protecting, isn't it?
Safeguarding is about protecting the site for that use. But there is also, an issue with a site which has been effectively not used for a significant period of time, as is the case here.
I can understand that as a general proposition, but in terms of Policy 5, anything other than protecting takes it beyond Policy 5, doesn't it?
It takes it beyond safeguarding as set out in Policy 5. Yes, I would agree.
Sorry, I'm just making sure I don't go back over ground that we explored earlier on. Just to touch on, well, sorry, just in passing, to make or to remind the reporters, as I put in writing in response to the Council's MPF4 submission, because the acceptability or not of retail use on this site is not, in my submission, an issue for you to determine as part of this inquiry. I'm not going to cross-examine this witness on the comments she's made because it doesn't seem directly relevant. So in not asking the questions, I'm not conceding anything. I'm just not pursuing a line which I feel is not relevant. I just wanted to make that clear. I'm just going to touch briefly on the issue of the release valve. I don't consider that, again, this is a particularly key issue. So I'm hoping not to spend too much time on it. Stuart, if we look at your recognition, which means I've actually got to find my copy again. It's at your paragraph 313. And at 313, you're discussing policy 26 of MPF4, and you say it offers a release valve for alternative uses to business and industry, although this is not a far-reaching or wide-ranging exception. And you go on, policy 26C indicates that other employment uses will be supported, and you continue. There's not a definition of employment uses within NPF4, is there?
No, NPF4 doesn't define either employment uses or what is envisaged precisely in terms of policy 26C in terms of other employment uses.
And in contrast, the Fife Plan Policy 5, for the purposes of the release valve, does list the various uses.
Fife Plan defines employment as class 4, 5 and 6, which is a fairly commonly held definition of employment uses.
Mm-hmm. But in relation to the release valve in particular, when we look at policy 5, if we go to the accompanying paragraphs or notes, I'm not sure precisely how they're described, we can see paragraph or note 8, there's a list of ancillary or complementary services or uses that would be considered as part of the release valve. So there's a fairly specific list there, isn't there?
Yes, there's a specific list of ancillary uses and a similar list of examples of incompatible ancillary uses.
Yeah, so in that sense, Fife Plan Policy 5 is more restrictive than the MPF4 policy.
Yes, I mean, I wouldn't consider the lists exhaustive, whilst they are lists of examples, and they are quoted as examples in Fife Plan Policy 5. I wouldn't see them as exhaustive, and part of the reason for that is planning is an evolving thing. Uses evolve, and new uses which the development plan 5 years ago not have envisaged being a use which was in demand or had to be accommodated somewhere. As a planner, it quite often feels like we're having to run to keep up with emerging technologies. So I wouldn't expect the lists in Fife Plan to be read as exhaustive. And given that NPF 4 operates at a different level from Fife Plan as the local interpretation of those policies, I would expect the local development plan to provide greater detail than is possible in a document such as in NPF 4, which applies nationally. I have to say that as a planner, I would also hope that guidance which will ensue will provide some clarity as to what is envisaged in terms of other employment uses. That's for the future, however.
Thanks very much. That was all the questions I had.
Okay, thanks very much. So as Mr. Warren suggested earlier, it would make sense for us to take the longer lunch break now so that we can just double check through the alternative statement of reasons that we've had emailed, just to make sure we don't want to add or change any of our questions on the basis of that. So it's 7 minutes past 12 now. So if we just resume again at 1:05. That's okay with everybody? Okay, and again, just a reminder that because we're part way through Ms. Stewart's cross-examination or questioning, there shouldn't be discussion of that with your representative. And the other reminder, just that people may want to switch off their videos whilst we're on the break. So unless there's any questions, I'll switch myself off now and see you again at 1:05. Welcome back, if we're back. Okay, so can I just check everybody can still hear me?
Yes.
Yeah, great. So Mr. Collar, you just finished your examination before the break. I've had a look through the statement of reasons, the version submitted. So I'm happy in terms of the questions I want to ask. I do have a few questions. I think a lot of what I had wanted to hear has already been covered. So I'll just ask these residual ones. Do it. And I think, yeah.
Excuse me, just before you begin, I do have a couple of questions in re-examination. I don't know if it would be appropriate for me to ask those now, or if you wish to proceed with you.
After I've asked my question.
Okay, thank you, ma'am.
And then, because there might be something arising from what I ask. Okay, and I think the only documents I'm going to refer to are Stuart's recognition and 5 plan. So that's document FC6. And within that document, I'm going to refer to policy 5. I'm also going to refer to the proposals for Duggetty Bay. So they're set out across pages 105 to 107. When I get onto those, so I'll just give you a couple of seconds. Okay. So I'm just going to start with something I've picked up from policy 5, employment, land and property. There is a reference in the policy to employment, land supply. I mean, it's not reading in there as that being a specific, there being a figure attributed to that. It's more that you would, as we've discussed already, resist losses from the existing employment land supply. But it did make me wonder whether elsewhere in the plan, and it might be somewhere I've missed it, is there an employment land requirement or an employment land target somewhere in the plan that attributes a figure to the amount of land you want to have in supply?
I'm definitively not the expert in terms of employment land supply. That would fall to colleagues. And as a planner, in terms of the requirement, the actual figure required, I would take advice on a case-by-case basis as to what the current position in any given area is in terms of whether there's a shortfall, an existing shortfall in the 7-year supply, or whether a proposal would cause a shortfall in the 7-year supply. And for that purpose, I would consult the colleagues in economic development.
Yeah, and I'll ask them. It was really just a very limited point to do with what is and isn't in the development plan itself. So you mentioned there the 7-year supply. I guess what I'm just trying to establish is it doesn't look to me as though there is a figure for what the 7-year supply should be at any time in the development plan itself. I just really wanted to check that that's the case, and then the details of that I'll ask colleagues.
As far as I'm aware, and under policy 5.6, sets out the requirements for the 7-year supply and how it is monitored, but doesn't set specific figures.
Okay. The next figure, the next question relating to the proposals. So this it's linked to that. So the first question I've got relates to proposals that are from there. These look like employment allocations to me. So over pages 106 to 107 of 5 plan. This is sites DGB 5, 6, 7 and 8. These are 4 sites in Dalgety Bay that are described as employment sites. I don't have, the proposals map isn't before the inquiry, so I haven't seen where those are on a map, but from the location that's down for them, you know, the address point and the descriptions, it sounds like they are potentially employment sites in or around the Hill End and Donnybristle industrial estate. So the first thing I wanted to do was just to double check, are those employment sites that were already in the existing employment land supply?
You were, yes. I haven't got the map in front of me at the moment either. Certainly 8 was the site.
So part of the reason I'm asking that is I think that when you were being cross-examined earlier, you suggested that a site that was already part of the employment land supply wouldn't usually be allocated for employment. So just picking up that it's like those 4 are. So my next question is, if those 4 sites were already within the land supply for employment, but they've also been picked out as specific proposals, is there a reason why the CPO land wasn't also in as a specific proposal that you know of?
The site is, sorry, can I just get a copy of the plan?
It's page, these sites are on page 106 and 107, no, and 108. There's 4 sites across those 2 pages.
I've got the list of sites, and the question is, why were they included?
Yeah, so the first question I gave, which I think you've answered already, but I'll just let you reconfirm. I was asking DGB 5, 6, 7 and 8.
Yeah.
Were they all already part of the established employment land supply? Or 5?
DGB 5, yes. Yes, I believe they were.
Okay, and as I said, that I was just really checking that because it sounded earlier as if the expectation was usually a site in the established land supply wouldn't be allocated for employment. So the question, my last question was, if those sites were allocated or...
That wasn't quite what I was trying to say. I think the previous line of questioning was about the difference between sites allocated for employment land and sites in established industrial areas.
Okay.
So not all allocated sites will be in an established industrial area. Highlands and Donnybristle estate is generally an established industrial area going back for years. So I wouldn't expect a site which is in industrial use or in employment use within an established industrial estate to be protected as being allocated in the development plan, I would expect it to be protected as being safeguarded for employment use.
Yeah, I understand that principle, but I'm really just keen to understand then if that's the general principle, are these 4 sites allocated sites, even though they're part of the established area as well? So are they, by being picked out there, are they allocated rather than just being safeguarded?
They're allocated, yeah.
Yeah. And so my question regarding the CPO land was, why was that site not also allocated rather than just being safeguarded, given these other sites were picked out as for that additional treatment?
I think, as far as I understand it, it's possibly a historical fact going back to the previous development plan, which the adjacent site and the site which is the subject of the order were both included as a proposal in the previous version of the development plan, and that proposal was to secure the improvement of that combined site, to create a new gateway to the industrial estate, following the grant of planning permission and subsequent the adjacent site. That gateway function was seen as having been fulfilled. From recollection, as best I can, back about 10 years, I suppose, part of that development of the adjacent site was expected to be sufficient to regenerate or stimulate regeneration on the site which is the subject to the order.
Yeah. Okay, so it was part of one of those sites. Only part of that previous allocation came forward, and rather than allocating the new reduced site that's the CPO land, is covered by the general policy 5 safeguarding. Okay. Another question about the proposals, and this is the Dalgety Bay housing proposals, which are on page 105 and 106. There's 3 sites down as described as housing. One is the OCLI site, which was mentioned earlier. One is Fulmar Way 2, which may have been mentioned earlier, and the other is a site at St David's Harbour, which I think is also in Dalgety Bay. That's not part of Hilland and Donnybristle, is that right?
That's correct.
Right. So these 3 sites, are they all sites that were previously in employment use but are allocated in the plan for housing?
The OCLI site was previously employment use and was allocated for housing following an appeal decision which granted, I believe, planning permission in principle for a fairly extensive area of housing.
Was that under, just when that appeal happened, was that during the time of Fife Plan, or was that the previous local plan?
Previous local plan.
Yeah. Okay. And the other 2 sites there, so DGB 002's Fulmar Way 2, is that a previous employment site?
That was an employment site. It's in the Hilland and Donnybristle industrial area. It was a site which was brought forward through Fife Plan at the reporter's request.
Okay. And the third one, St David's Harbour, DGB 004, was that employment land previously?
Sorry, I don't know whether that was employment land previously. I'm aware of the site and that there's been a long-standing proposal for housing with a restaurant, but I'm not familiar with the details behind that. Apologies.
It's okay. Can you remember whether that was put in the plan by the council at the outset?
I think that was in the previous plan as well.
Okay. Thank you. I think just double checking if there's any more questions. A lot of them are answered already.
Sorry, I'm just remembering St David's Harbour was an appeal decision.
Was the appeal decision? Okay, thank you.
But going back, I think the actual appeal probably predates my employment with the council in 2008. Although I do remember taking an update report to committee shortly thereafter. But it was an appeal decision.
Yeah, thank you. That's helpful. I mean, what I was wanting to just check was whether any of the instances in this Dalgety Bay area where a previous employment site has now been developed or allocated, identified for housing, whether any of that had been actively planned by the council or, allowed at application by the council rather than being appealed. So you've answered in terms of those sites. Thank you very much. I don't have any more questions. I'm just going to ask Mr. Warren whether he wants to ask a question.
I have got one more question, but it is only one more question, you'll be glad to know. So it's really about I'm interested in the input that the planning service has had into this CPO process, and to what extent, as you understand it, was the pre-application query about retail development on the site I suppose a sort of trigger for the CPO process? Was it a trigger?
No.
Okay, that's a clear answer. I don't need to take that any further. Thank you.
Absolutely not.
Mr. Devlin, when you're ready with any re-examination, you're welcome to. Thank you.
Thank you very much, sir. Stuart, first of all, hopefully you have a copy of section 1.9 of the Town and Country Planning Scotland Act 1997. I'll ask you to read that for the benefit of those listening. Would you mind reading out, please, section 189(1)(a), please?
Is suitable for and is required in order to secure the carrying out of development, redevelopment, or improvement.
Mr. Collar spent quite a bit of time asking you about necessity here. Could I ask you please to read subsection 2, including subsection 2A of section 189?
Local authority and the Secretary of State, in considering for the purposes of section 1A, whether land is suitable for development, redevelopment or improvement shall have regard to A, the provisions of the development plan so far as material.
Can I ask you, please, and I recognise this as perhaps a legal interpretation point, but what would be your interpretation of what the decision maker has to do under those two provisions? Quite a big question. Comparing section 1891A with what is being asked under section 189 subsection 2.
So in terms of that, I would suggest that it has to be suitable for a development which accords with the provisions of the development plan. And the land has to be, I'm going to use the word needed instead of required, to allow that development to be carried out.
Okay, thank you very much. Mr. Collar also referred to the order itself. The order states securing the redevelopment and improvement of the area in the interest of proper planning of the area. Can I ask you to look at section 189, subsection 1, and then subsection B, please, and to read that for the purposes of the inquiry.
B states is required for a purpose which it is necessary to achieve in the interests of proper planning of an area in which land is situated.
Do you have a view about, or could you offer the inquiry your views in terms of proper planning of this particular part of Dalgety Bay?
Planner, I'm not used to being asked to give verbal interpretations, I have to say, but the proper planning, in my view, would be to secure employment use of a site within a safeguarded industrial area, which, you know, aligns with the provisions of the development plan.
Thank you. And then my final question, Mr. Collar referred to the Muir Homes site and applications regularly being refused there. Are you able to tell the inquiry, you give information to the inquiry rather, why those applications are or have been refused?
The site is set out on the development plan as requiring to be accessed by means other than from Fulmer Way. Fulmer Way being one of the main access routes into and through the industrial estate. That access has proved difficult to achieve. In addition to that, it has proven to be difficult to provide protection from this amenity, particularly noise, for future residents of the site because of the proximity of general industrial uses surrounding the site. I think there have been 3 applications to date and 1 live application, with various layouts and various housing numbers. But to date, those have, obviously with the exception of the live application, those have been refused on different grounds. The proposals have differed in terms of the means of access, the separation distances, the number of houses. There have been design issues in terms of connectivity to the settlement itself. So there have been different issues, but ultimately the proximity to noise generating industrial uses has been a substantive part, and the difficulty with gaining a suitable access other than from Filmer Way.
Thank you very much, Mr. Chair. I have no further questions in re-examination.
Thank you very much. I don't have any additional questions arising from that, so that's the end of Ms. Stewart's segment. Really pleased to hear. I believe the next witness we're hearing from on behalf of the council is Mr. Riley. So I'll just give you a little reminder of that. Other than that, I think it's back with you, Mr. Devlin, to introduce your next witness and take any evidence in chief.
The next witness for the council is Andrew Riley of Andrew Riley Associates Limited. He'll be speaking to market demand for class 4, 5 and or 6 uses at the location of the CPO land. I don't have any questions for Mr. Riley at this time, ma'am.
Okay, in which case, as soon as you're ready, Mr. Collar, you can begin your cross-examination.
Thank you, Madam, and good afternoon, Mr. Riley. Again, just to keep the housekeeping straightforward, the documents I might be taking you to, some of them we might not actually need to look at. Your industrial land report, which is FC13, your precognition, understandably, the now infamous statement of reasons, and I'll take you to a comment in Mr. Stewart's precognition, but I've got it here, so you might not necessarily need to actually look at it. I could read it to you, but I am going to refer to that. Starting with your industrial land report, but it's not really about the content as such, and this is just contextualising. It's dated January of this year. That obviously post-dates the CPO, but just to check, when were you instructed by the council to prepare the report?
It would have been last November, December, I think.
And as I said, that post-dates the CPO. The CPO is August of last year. And just so that we're all clear, did you have any involvement in the CPO process?
No.
And turning to your recognition, and looking at paragraph 3.1, in your paragraph 3.1, you start by referring to your report, and then you say the council is promoting this CPO ultimately to introduce an oven-ready industrial development land site into the supply. If we look at the statement of reasons, and it's going back to the page that was thwarting me before. So it's within section 2 purpose, but it's the second page of that. And it's the penultimate paragraph on that page. So it starts, the council, sorry, maybe it's not actually that one that I wanted to mention. Just give me a minute. No, it is, sorry. I'm reading my own notes wrong. The penultimate paragraph, it starts, the council proposed to carry out remediation and site servicing to ensure that the land is made available as effective serviced employment land. So can we see there, the council's proposals are not just about industrial land, it's about employment land.
I disagree with that.
And we've already heard within the policy 5 of the local development plan, 5 plan, that employment land includes a class 4, 5 and 6. So again, that's not just restricted to industrial land. Yeah. And to pick out an example within that, class 6 use, storage and distribution, generally speaking, that includes, well, that would provide fewer jobs than, say, class 4 business, and those would tend to be lower quality jobs as well.
Depends on the end user. I'm not convinced the site's big enough for a major class 6 operation.
Okay, and one thing I wanted to check with you, your report consistently refers to industrial land. Are we to read it in that narrow sense, or are you using industrial land as shorthand for employment?
I see the two as similar. Different levels of employment within 4, 5 and 6. But my remit was to look at industrial land, and that was the basis of my report. It was industrial land supply.
Yeah, so in that sense, you were asked to report an industrial, you've reported an industrial, and that's in that sort of narrow sense, albeit you've explained that it is potentially similar to other types of employment land.
It is, and one has to take it in the context of the site overall. It is an industrial estate, and it has a variety of employment uses within the industrial estate, but it's principally industrial.
And then in your recognition again, if we go back at paragraph 3.5, you deal with demand levels, and in that paragraph, the final sentence, you say, this, in my opinion, lends support to the council's contentions in its statement of reasons and other submissions that there is and would be demand for an industrial development opportunity at the CPO land. That isn't accurate though, is it? Because there's no actual evidence before this inquiry of actual demand from an occupier interested in the CPO site.
It's an opinion. It's only my opinion of what I believe the site would lead to. I think there would be demand for the site.
Yes. So the reporters could delete your reference to there is demand because factually speaking that's incorrect.
All one can relate to is what's been happening within the environment, and there has clearly been demand within the environment. I would find it difficult to surmise that if this site were to be brought to the market, it wouldn't attract the same level of demand as elsewhere.
Well, that covers the statement of there would be demand. What I was asking was, can the reporters delete the reference to there is demand, because actually that's factually incorrect?
We don't know because the site's not been tested, so I would tend to agree with that statement. I merely took it as a view and an overall approach for demand within the estate.
Yeah. And if you just bear with me, I'm juggling references again as to whether it's a reference to your report or your precognition. Yes, if we turn to your report, which is document FC13, and paragraph 3.7, which is the section where you deal with industrial land. 3.7, you say, other than the site at Beech Way, presently there are no sites available for industrial development. But if we go back to your 3.6, where you summarise the situation, for 24 Ridgeway, which is the second bullet point, you say they are currently being marketed in a number of interested parties. So, according to your report, that is a site which is available for industrial development.
Well, I was advised at the time of the report that it was under offer. It had achieved a number of interested parties looking at the site, and that the site was about to go under offer. So it would have been removed from the availability list.
Well, that's not what you've said in your report, though, is it? Because in paragraph 3.6, you say currently being marketed in a number of interested parties.
It's now going under offer, so I was told at the time it was under offer.
But that's my point. You were told at the time it was under offer, but that's not what you said in your report. So do you want to amend what you've put in your report? What are you actually asking the reporters to note as the position?
I'm happy to amend it to show as it stands that it went under offer. It was possibly after that January date. But at the time I was advised it was under offer, or going under offer.
Well, there's an important difference. Going under offer means it's still available, and the offer might never arrive. So which is it?
Well, that's not strictly correct. I mean, if a site is actively being marketed and a level of interest is noted, and then negotiations go into detail, in real terms, one would normally take that site as being under offer. It would then go formally under offer thereafter, which I believe is the process that this site has gone through. But because of the activity and what was ongoing at the time, I made the assumption the site had gone under offer. But if you want strictly being correct, it wasn't under offer at the time. I've subsequently found out.
Right, I'm getting slightly confused. So is it your evidence that you were told after the report that the site had gone under offer?
I was told at the time that there were a number of interested parties and the site was going under offer. And my expectation is that it would have been under offer. It certainly wasn't available to the market at that point because the interest was so significant. But technically, as my report stands, it's correct. So it would have been, in theory, available.
And have you checked what the current position with that site is?
Yes, I've been told it's under offer.
And when were you told that?
2 weeks ago. 3 weeks ago.
Right.
It was confirmed by the agent 21st of April.
It was confirmed 21st of April.
The agent has advised that the site is under offer on that date.
Sorry, you're saying the agent advised you as at 21st April?
He's confirmed at 21st April that the site's under offer.
Right. And turning then to staying within your report, at 3:11, you say the lack of development land opportunities is similarly limited at Dalgety Bay. In view of the recent activity, development by the council and the sales that have occurred, the resultant position demonstrates a clear lack of any industrial development land opportunity. Presumably, that is on the assumption that my client is not open to industrial development of the site.
I'm not aware of that. It's a matter for your clients, I would think.
I asked you if that was the assumption that you were making, because you've said in your report a clear lack of. I read that as being there is no opportunity, and I'm putting it to you, if my clients were open to industrial development of that site, there would be an opportunity.
Agreed.
Yeah, so you've drawn the assumption that they're not interested.
Well, I'm not aware of it. I haven't spoken to your client about it.
No. So you spoke
market.
to, sorry, I should let you finish.
All right.
So you spoke to an agent about the position with another site, but you've never contacted my clients to confirm their position about their site.
I've not contacted your client, no.
No. And moving on within your report to your section 4, where you deal with demand levels. And 412, you say the Amazon development is ensured interest in the wider M90 corridor, and the recent site servicing of 5 Interchange North has attracted interest, with part of the site now under offer for industrial warehousing purposes. There remains a substantial site at 5 Interchange South. However, this is yet to be fully serviced, as such not available for immediate development. The same comment could be made about my client's site, couldn't it? It has yet to be fully serviced and is such not available for immediate development.
It could be, yes.
And just in that regard, Mr. Stewart's recognition, I don't know that you necessarily need to have it to hand, but it's a paragraph 2.4 if you want to have a look, and for the reporter's benefit for the reference. Mr. Stewart says development was largely halted during 2020 and 2021 due to COVID-19, with increased material costs throughout 2022, also slowing down developments. That has been the case with developers across the UK. Recent construction tenders have suggested costs are coming back down slightly, which will make more schemes financially viable. Do you agree with those statements?
To a degree, I think the costs are coming back down. I think generally schemes will be more financially viable. That very much depends on the locality.
Thanks very much, Mr. Riley. That was all the questions I had.
Thank you.
I do have a few questions as well. I'll just take a minute to look down my list though and cross off those that have been covered already. Okay, I do have a few questions, so I'll get started on those. I'm going to come on to some questions arising from specific statements in your recognition, but just some general questions at the beginning, and you might not be able to answer these. They might be for council officers themselves to answer later on in the inquiry, so let me know if that's the case. The first question is around the sort of the purpose and the brief for your report. Mr. Culler's already mentioned the fact that it's certainly when it was published that postdates the CPO. Do you know, was the report specifically prepared to support the CPO, or has it got a wider purpose than that?
I was asked to provide an overview on the land availability and supply demand within South West Fife.
Yeah.
The full knowledge that the CPO was underway.
You knew it was underway, but I think you said earlier you weren't involved in it. You've said that already. Is there any interaction or any relationship between your study and the employment land audits that the council prepares? So the audits, there isn't one before me, but my understanding is they sort of monitor and track in terms of hectares, the availability of land. Is your report reflective of or complementary to that, or is it just something completely separate?
Totally separate. My view is all about what's driving the market. It was nothing to do with the land audit trail.
Okay, and it's not relating that back to anything that's in the audit target or requirement, no. In terms of how you went about compiling your research, are you able to just very briefly summarise, how you did that, what methodology you used, or how you went about coming to the conclusions that you've drawn?
Yeah, I did research what was available via the normal websites, which was through the property websites and local agents, making various approaches to local agents, and then discussing what activity was ongoing with Fife Council sites. I would then draw together my views on what land was available immediately for development, what was available in the future, and taking a broad brush approach as to what was happening in South West Fife mainly following the research through the websites and the agents, various agencies, drawn through my own local knowledge.
Okay, and you, in answer to Mr. Collar earlier, you mentioned that you hadn't spoken directly to the objectors. Is that the same for all landowners? It was through agents rather than trying to approach directly the landowners, or did you speak to some of those?
You would normally deal through agents if you have an agent contact. If you knew they were aware, if they were involved in the site, you would speak to them direct.
Okay. Returning to the recognition now. At paragraph 3.3, you say that the CPO land needs to be remediated in order to enable development consideration. And the question is, how does that statement reflect the fact that the landowner, the objector that we've got here, has been looking at options for the site? I think, did you say you weren't aware of that at all?
Aware of what they were doing with the site, knowing the site as I know it through my own personal knowledge, it will take some work to get it ready for development purposes.
Okay, so you were assuming there, based on your knowledge, that it wasn't likely to be of interest to a private developer in the current circumstances?
I think it would be wrong to say that it wouldn't be of interest. I think it would almost certainly be of interest. It's all about whether it's ready for development, and that in itself will, to a degree, be dictated by the price. If you don't ready the site for development purposes, then the price would be adjusted to reflect that, and the purchaser would then deal with those issues. But I do believe it would be of interest to the market generally. But that's my assumption.
Thank you. Next question's on paragraph 3.4 of your recognition, where you indicate that in your view there's a shortage of land available for development of industrial uses at present. And I just wanted to check that in referring to a shortage there, are you meaning there's a shortfall in the supply of land against some policy target, or are you, again, are you expressing a personal view that there's unmet market demand in the area?
It's a personal view. I'm not involved in any target for land supply. It's driven by my personal knowledge. I've been involved recently in 3 searches for land for development purposes, for owner occupation, design and building, and my study showed that there was a lack of suitable land.
Okay, thank you. And then still in paragraph 3.4, you also say, in my view, there are only a limited number of sites available for development for industrial uses. And I was keen to just clarify what sites there were. I think when you were talking to Mr. Collar earlier, he picked out a reference in it was either your recognition report where you'd said there was only Beechway available, but here you say there's a limited number of sites available. What are those sites?
The limited site, I mean, obviously the CPO site is one of them, that presupposing it was to be available, that would be of interest. There's a potential site at Interchange. There was a potential site at Dunfermline, which was part of the former FMC, but it's pretty limited. It's an area which is pretty high in terms of demand for industrial use, and land supply is somewhat restricted when compared to other areas.
Okay. So when you're thinking about where might market demand be met, you're not restricting your scope to Duggetty Bay. That's taking in some wider areas where there's land that you're aware of as well that could maybe pick that land.
It's a wee bit wider. I mean, it's looking at southwest, what we call the southwest wedge, which would take the Bridgehead area into account.
Okay, thank you. Next question has been covered, so I'll skip through. In paragraph 3.6 and 3.7, again, this is still in your recognition. You consider market constraints on the development of the site. Obviously, the site was purchased by the objector relatively recently, so in terms of its lifespan of how long it's been vacant. I mean, you maybe didn't know about the objector's interest before today, by the sounds of things, but now you do. Would that change your view on market constraints?
In what respect do you mean in terms of availability?
Yeah, in terms of the likelihood of the site being developed through its current owners, rather than requiring intervention to stimulate that private interest.
It's very much dependent on the viability and the cost of the remediation and site servicing for the site. Market values in Fife are still very low, and it's difficult to create viable sites if there is extensive work to be done.
Okay, and the other question I've got about that, and again, you might not be able to answer, given you're just becoming aware of the owner's interest, but is the sign that the site has been sold in the last few years, is that in itself a sign that there's an increase at all in private interest in development in the area?
The subject premise site.
Yeah, the CPO land.
When you say it's been sold in the last few years, I think it was part of a package, I believe it was sold. Site's been in its current format for some years.
Yeah, so I don't know about a package, but I'm aware the site, the current owners took ownership of the site, I believe it was within about the last 5 years.
Yeah.
And the question is just, is that, because the site had been vacant for a long time before that, is that a sign that there's an improvement in terms of market interest in developing the CPO land, like such as that?
It's difficult to tell because it wasn't. I don't think it. Well, I may be wrong, but I don't think it was bought individually. It was part of a wider acquisition, so it'd be difficult to determine whether that was any direct influence or views reflected current demand within the area.
Okay, and I don't know anything about a package, so I won't get into that. In paragraph 3.7 of your recognition, you say that remediating and servicing the CPO land would mean market demand for industrial land can, to a degree, be met, at least in part. So there's a couple of caveats there. With those caveats, are you suggesting that the CPO scheme wouldn't fully resolve the supply shortage in the area or resolve the issue of this site?
I think what I was meaning there is taking away that constraint would give a chance for development. One of the difficulties within the Fife market is the sustainability and viability of any project. Rental levels are very low, capital values are relatively low, and it's difficult. If there is major works required to the site, in my view, without any third-party intervention, it would be almost impossible to make it work.
And in here, though, you're saying that even with that third-party intervention, there might still be.
I think the third-party intervention will make it possible. Okay. Through the council, there is an opportunity that it could be brought back to the market, as has happened in the sites further up, further to the east of the site.
The next question, again, you might not be able to answer because it's sort of based on my understanding of what the 7-year employment land supply for Dalgety Bay is intended to be. So I think in the Fife employment land strategy document, which is one of the documents before us, there's a reference to an allocation of, well, not allocation, there's 2 hectares assigned to Dalgety Bay, I think, in terms of what it's intended to contribute to the general land supply over the 7-year period. In paragraph 4.3 of your recognition, you talk about a previous programme of council acquisition. There's also been some movement on some sites in the industrial estate in the last few years, partly as a result of that council programme of work. Do you know whether that council activity has resulted in that 2 hectares or land to the effect of 2 hectares coming into the employment land supply in recent years?
I'm not aware of that. I've been involved in the land supply discussion.
I can ask the about it. I think that's all the detailed ones on the recognition. There's a couple of other possible ones. I'll just check whether I need to ask them. Paragraph 4.15 of your report. You're talking here about some of the impacts of the market demand in this area not being fully met. You suggest that the squeeze on industrial land in southwest Fife is creating a level of demand further north, and that this has enhanced demand at the Avenue Lochgelly.
Yes.
I just wanted to ask whether is that a problematic thing, or is that a positive thing in terms of something that stimulated new supply in Lochgelly?
I would say it's positive for Lochgelly. It creates a dilemma if you need to be in southwest Fife. The difficulty with southwest, with Fife generally, is a bit of a hierarchy system, and those that want to be in Bridgehead or southwest don't really want to go east or north. So it's helped to a degree. The lack of supply has helped to a degree the avenue, and the sale of the land there has been very, very popular.
That's all the questions that I've got. I'll just check, Mr. Warren, do you have any additional questions?
Yes, not many. You've answered the vast majority of my questions there. So you helpfully clarified that your report FC13 is kind of a standalone document separate from the employment land audit. Did you use the employment land audit to inform your report, or is it a completely separate independent piece of work?
It's totally independent. I made no reference to the land audit at all.
Can I ask why not? Out of interest, it's not a criticism that you didn't use it. I'm just interested, given what the employment land audit is intended to do, as to why you didn't refer to it.
I was pretty comfortable with my own knowledge of the market and my involvement with various clients within the southwest sector. I was pretty familiar with what's available there anyway. And it was more a case of driving down what has happened over the course of the last few months. So I was relatively relaxed that my own knowledge would suffice.
And can I, on that point, can I just ask you to clarify again from my own notes as to kind of your sources of kind of how you know which sites are to be kind of counted at any given time? What sources do you use?
It's the property websites and local agents and various contacts. The property industry is driven very much through a contact network, and we make various approaches to other agents to drive out what's been happening. And obviously your own personal knowledge of the market. I'm quite fortunate that I know the market very well.
Adams has asked you about the kind of correct geography. You know, I appreciate that you haven't used the employment land audit. You'll note that the employment land audit looks at settlements individually and looks at Dalgety Bay, and we've been given some figures about the shortfall in Dalgety Bay. But in terms of your evidence, the kind of the appropriate geography that we should be thinking about in terms of employment land supply is Southwest 5. Is that correct?
Yes, I believe that's where the biggest demand is.
Okay. Thank you. I've not got any further questions. So, Mr. Devlin, back over to you when you're ready. Thank you.
Thank you.
I just have one question, Mr. Riley. Mr. Collar directed you to paragraph 2.4 of the recognition of Mr. Stewart, a landowner. Can you just provide a bit more information in respect of your professional opinion as to development on this particular site, the CPO land, given segregation, etc., requirement and financial viability of schemes in respect of land?
The difficulty I foresee is if the extent of site servicing is so significant, it can have quite a significant bearing on the end land value, and the end construction, the rental levels don't support high cost profiles within development profile. There's no doubt COVID has had a major impact on the construction industry. Construction costs have gone up dramatically, and if you add those to potential increased costs in remediation and/or site servicing, you end up with a site that becomes effectively unviable unless there is potentially intervention. And it's within this site. It's in Fife, it is difficult to see justification. The most recent developments have all been done successfully, it has to be said, by Fife Council and creating starter units. But if one looks at the cost profiles vis-a-vis the end returns, I think it's a struggle to make them work.
Thank you, Mr. Riley. I don't have any further questions. Thank you.
Sorry, that was just me trying to operate my mouse right screen to unmute myself. Okay, so that's the end of your evidence session, Mr. Riley. So thank you very much for answering those questions for all of us. The next witness is Mr. Ronnie Hare for the council. I'm wondering whether it might be worth taking another very short break now, just before Mr. Hare gets started.
That would be super.
Everybody happy with that? Okay, is 10-ish minutes enough for a bit longer? What about we come back at 2:30?
Thank you.
We'll do that. Thank you. Welcome back again. So as soon as everybody's ready, Mr. Devlin, you can introduce your next witness.
Thank you, ma'am. The next witness for the council is Ronald Hare. He's the property investment and development man for the economic development part of the council. He'll be speaking to the requirements and need for the CPO. I don't actually have any questions in chief for Mr. Hare, so Mr. Collar can just proceed to cross-examine.
Okay, over to you, Mr. Collar.
Thanks very much, and good afternoon, Mr. Hare. It's interesting because I'm not sure where you are yet. We'll get there. I don't think I've got any particular documents I'm going to refer you to other than your precognition. So it might possibly be a passing reference, but nothing that we need to look out yet. Again, to start with some contextualising, were you involved in writing any of the statement of reasons?
Yes, I was.
In your precognition at paragraph 3.1, this is section 3 where you're dealing with the background, and you refer there to the Hill End and Industrial Estate Regeneration Action Plan, which is FC12. I don't think we actually need to go to the document. It's dated August 2013, so it's almost 10 years old.
Yes, that's right.
And at your 3.4, you outline significant steps that the council has taken over the last 10 years. There's been no review or refresh of that action plan since 2013 to take account of those significant steps.
I think it's an evolving process. We haven't revisited the actual action plan, but I think what we've been doing over the last 10 years is actually delivering the contents of the action plan and some of the key recommendations within that. So things like estate signage, landscape improvements. We've bought the former Havelock Europa site at West Way. We bought 24 Ridgeway. We carried out the demolition of the buildings that Havelock occupied previously, carried out site remediation, and we've carried out 2 phases of new build industrial units on that. So we haven't really felt the need to actually update the actual action plan. I think we're still very much in the process of delivering of that, but obviously we have to give licence to the action plan, and if we feel that we need to identify any new actions or other opportunities come about, then that's something we can give consideration to.
And really, that was the point I was making. It's an evolving situation. So the point for the reporters to take away is the action plan itself is out of date, in the sense that to get the current position, they need to look at the action plan as well as the comments you've made in your precognition to get the current situation.
I think that's a fair comment, yeah.
And just to pick up one matter that was mentioned in the objection that we lodged on behalf of the landowners that hasn't I don't think been directly commented on in the council's evidence. For the reporter's benefit, I don't think the objection has a document number, but the particular point I want to pick out, I don't think it's essential for people to have a copy of the document in front of them. At 10.1.2 in the objection, we say in July 2015, the council granted planning permission for a mixed-use development immediately adjacent to the western side of the CPO land, and references were given there to the relevant planning permissions. The site is currently occupied by Aldi, Screwfix, Domino's, Bathroom Centre 5, Specsavers, Subway and Greggs, and a Costa Coffee drive-through is also planned. The council acknowledged the development was significantly contrary to the development plan as it introduced retail, food and sui generis uses in an area designated for employment use in the development plan. So in addition to what you've listed in your precognition as actions undertaken by the council, the reporters should also take into account that mixed-use development next to the CPO site that the council granted planning permission for, despite being significantly contrary to the development plan.
Yeah, I think that's a fair comment. I think that my understanding was, and planning obviously gave this consideration as well at the time of considering the planning application, was that an element of mixed use was appropriate as part of the wider estate regeneration. I think that's noted within the Yellow Book report as well, that allowance could be made for alternative uses where appropriate, and it was considered appropriate that the Western Gateway site, being the very first site as you come into the whole estate from the western side, was appropriate for a mixed use allocation. I was involved with that as a consultee, and we did secure a minimum amount of employment premises to be delivered by the developer, which happened. And we also secured a commuter payment for the loss of that employment land. I think it's also, well, it wasn't actually employment land as such, it was employment premises which were in a very poor and derelict state of repair. It already had included a number of mixed uses as well, including a children's nursery within the site and play centre, I think. So it wasn't entirely occupied by business premises, but it was in a very poor state of repair and probably not fit for purpose for any business coming into the estate. So I think the view was taken that some element of retail and leisure would be appropriate in that particular location. But beyond that, the rest of the industrial estate should maintain its character and integrity and be retained for employment use, and hence the reason the CPO land was retained as safeguarded employment land.
And staying with that adjacent site and jumping for a moment in your precognition, so apologies for jumping, but it just makes sense to stay with this particular issue. At your paragraph 4.1.2, you say the CPO land is in a particularly prominent location within the industrial estate. It's the first vacant site which anyone entering the estate from the main western gateway will notice. So you say it's the first vacant site.
Yep.
But in actual fact, the first site that anyone will notice is that mixed use site that was granted planning permission in 2015.
Yeah, I think what I was probably meaning, if I didn't say that, I'm sorry, but I think what I was meaning was it was the first site you see as you actually enter the industrial estate proper beyond the Western Gateway site, which is the area of mixed use.
Yes. So when you say the CPO land is in a particularly prominent location within the industrial estate, you mean that's on the assumption that the gateway site isn't within the industrial estate?
Well, I think it's not an industrial use, and I think the industrial uses do commence just at the point where you see the CPO land. It's directly opposite Ingenico on the other side of the road, on the other side of Ridgeway. So that's really where all the industrial uses actually commence. So I think that's probably fair to say now that that's where the industrial estate proper actually commences.
Because I've jumped to your 412, I'm going to stay there for a moment. The final sentence of that paragraph, you say, similarly, without the intervention of the council, it is likely, this is the CPO land, to act as a deterrent to any potential investor considering Haddy as a potential location in which to invest. If we hold that thought and go to your 415, 415, you refer to purchase of DGB 008, an identified purchaser for the site at 24 Ridgeway, and occupiers at DGB 006 and 5.
Yep.
So there are at least 4 sites with investors who have not been deterred by the condition of the CPO land.
I think I was making a general point that it would be much better if this CPO land was developed and brought forward for beneficial use. It is detracting from the immunity of the overall estate, attracts fly tipping and fly posting. And we've had numerous complaints over the last several years about the state of the repair of that from both businesses and from residents. So I think my conclusion is that it would certainly help to improve the opportunities for investment, and it may well be that the council's actions elsewhere have helped to ameliorate the dereliction and the overall condition of the whole estate. And purchasers are buying sites in spite of that dereliction and those issues of immunity.
Well, I understand the point you're trying to make there, but it goes beyond what you said in that sentence. The point I'm really trying to put to you is, given what you've said about sale, etc., of other sites within the estate, I think I've got to invite you to delete that final sentence, because on the basis of the history you yourself have outlined, that's just not true.
Well,
it has not acted as a deterrent.
Well, what I'm saying is a general point, and I think what I said was it could detract. Potentially contribute
How
to
could
existing
it detract?
businesses.
Sorry, I shouldn't be interrupting you.
Apologies. What I'm saying is that some employers, some businesses might be dissuaded from investing in the estate. Obviously, not necessarily all employers or businesses or inward investors might be dissuaded from investing in the estate, but there's a potential that could happen logically.
Well, I think the reporters have taken the point that, logic or not, it runs counter to the evidence you yourself are giving. The other point is, the council's case seems to be the CPO site is the only available site. So what potential investors are there to detract? There aren't any other sites for people to invest in.
Well, I think it's the opportunity that lost that this site could be attracting investors if it was marketed openly and transparently to the open market. As Mr. Riley indicated, we're now under commercial offer with a purchaser for 24 Ridgeway, and we've had 15 inquiries since the site was first marketed in September, and we were unable to satisfy the full demand that we've discovered ourselves, in which we knew that there was a latent demand in that area for, and I think the evidence has shown, from my point of view, that I'm satisfied that there is sufficient demand in the area for employment sites in Dalgety Bay. It's a very large estate. It has around about 120 businesses employing over 2,100 staff. So it's clearly a very popular location for major businesses such as Ingenico, BE Systems, Collinsberg, and so on, as well as Mr. Riley indicated, a range of smaller, medium-sized businesses as well. So I think it's probably self-evident that the estate is very popular with business, and it would clearly be anticipated that if the site was marketed, there could well be demand for the site, but it's not openly marketed.
I'll come back to that, but I want to insist on the narrow point that I am making. In your precognition, which is the statement of your evidence that you're giving this inquiry and that you're expecting the reporters to take away, you've said without the intervention of the council, the site is likely to act as a deterrent to any potential investor considering Haddy. I put to you that the logical conclusion of the council's case is there is no other site for an investor to be interested in. So the condition of the site cannot put off an investor interested in the site. So again, I've got to invite you to delete that sentence, because in the context of the case, it's just nonsensical.
Well, I'm not sure. I said maybe I'm reading slightly differently from you, obviously, but what I said is that potentially contributes to any existing business occupier in deciding to relocate to other locations or in deciding not to invest in their existing premises.
But you said it's a very popular location. So why would they go somewhere else?
Well, I suppose if all else been equal, they had a choice between an estate which was been fully regenerated or didn't have the issues that Haddy had. It may well be that it comes down to deciding between Haddy and that other location, and all else being equal, they might prefer the site which is has been well maintained, or overall it's been regenerated.
Again, that runs counter to Mr. Riley's evidence that I'll need to get this right, southwest wedge, I think it was, apologies if I've picked that up wrong, was of particular interest to users. So if they particularly want to be in the southwest wedge and this estate is a popular location, why would they be thinking they might up sticks and go somewhere else?
Well, I'm not quite sure I follow what you mean. All I'm making is a general point that it creates a poor image for the estate. And if opportunities might not be right at this minute, there might not be sites immediately available right now, but other sites could be made available in the future. It could well continue to detract or have a negative adverse impact on our ability to attract investment into the industrial estate. But I think, yes, there is a lack of employment land generally in the southwest area, and companies are forced to take decisions about going to certain locations because of that lack of supply.
Moving on, you're placing quite a bit of weight on the poor image of the estate that this site projects. Have you or any of your colleagues spoken to planning colleagues about using planning powers that exist to deal with land adversely affecting the amenity of a neighbourhood?
Not specifically, no. We've certainly taken action ourselves to remove fly tipping from the area, and we do get complaints, but we haven't used any other planning powers available to us. But you know, we do speak and have spoken to the current and previous landowners about the condition of the site. But I think my point is that it's been like that for over 20 years. Okay, previous buildings were demolished about 10 years ago, but for the last 10 years, the site has been lying vacant, and it just naturally attracts antisocial behaviour. And I don't think that's going to go away without some intervention, either by the landowner to redevelop it, or for the council to acquire it, service, remediate it, and proactively market it for business use.
I apologised earlier for jumping around, and I'm now going to jump back. The previous paragraph 411, which is the first of the reasons you give why the CPO land is required. You say there it's included within the vacant and derelict land register, has been for a period of more than 20 years, not been in beneficial occupation for a significant period of time, little or no action on part of current and previous landowners. Purchase would allow council to invest in remediation, actively market the site and so on. I'm reading it in short. The council bringing it back into or to actively market it, facilitate development of employment uses, that's a positive objective. But there's nothing within your 411 that actually shows a need or a requirement, is there?
Well, I think it's self-evident there's a need for something to happen with the site, otherwise it just lies vacant and derelict indefinitely. So I think in and of itself, there is a need for some intervention, either by the landowner or by the council. And on the basis of historic precedent, no action has been taken by the successive landowners. And in the failure of that, in the absence of that, I think the council has to intervene. We have got, over the years, numerous complaints about the state and the age obsolescence of the whole estate, but this site has been identified as a particular issue, and we have made consistent approaches to the landowner to try to do something with the site. Without success, we've even suggested a joint venture agreement, which was not accepted. The site has not been marketed. There's a board on the site inviting inquiries, but it's not on any websites. It's not on all the usual commercial websites, Novaloka, CoStar, Property Link, etc. It's not even an agent's own website. And we understand that the preferred use for the landowner is an alternative non-employment use. But even that has...
No, it's your evidence, so I shouldn't be interrupting you. So please don't apologise. My apology. Several points there I was going to pick up with you. In your 411 that we were looking at, you say there, the second sentence, as such, the land has not been in beneficial occupation for a significant period of time, with little or no action on the part of current and previous landowners to change this position. The objection that we looked at earlier at 5.4 included a list of steps that the current landowner has taken. It's not accurate to describe that as little or no action, is it?
Just give me a second and I'll get that. It's in
The objection.
the objection.
Yep.
Yeah, that sets out a history since November 21, so not much over a year ago. And obviously, you know, we understand the conclusion of that. I think it set out the preferred route for the landowner is to seek an alternative use. But there's been no action in terms of marketing the site for its designated use on the site plan.
Well, I would just like to be clear. Is it your position that what is set out as the steps that the landowner has taken between November 21 and September 22, is it your position that that is little or no action?
I think it's some action, but that postdates the date upon which we got approval to promote the compulsory purchase order through our cabinet committee at the time. And Before that, we have asked the landowner repeatedly to engage with us with a view to the council buying the site, or entering into a joint venture, or to market the site, or to do something with the site to bring it back for a positive use.
Mr. Hare, I'm puzzled by the relevance of when you had the authority to proceed with the CPO, because the landowner was unaware of the CPO until it was served. So why did you refer to the start date as being when the council got authority to proceed with the CPO?
I'm pretty sure that the landowner would have been aware that we secured committee approval to that before we actually submitted the CPO papers. And certainly we had spoken to, not specifically Graham, but other colleagues to advise that we were going to promote a compulsory purchase order.
So are you trying to seriously suggest that the only reason the landowner did all that work and incurred all the expenditure was to counter the fact that the council were about to go ahead with the CPO?
No, I don't think it said that, Natalie.
Well, it was the clear implication. So if I've picked up the implication wrong, please correct me.
Well, I don't know what was in the mind of the landowner, to be honest. But
Well,
you know, the site has been owned since, my understanding, 2018 without any action such as that having been taken.
Well, again, I'm puzzled. Why did you draw significance between the date the landowner started steps and the date that the council got authority to proceed with the CPO?
Well, I don't know. As I say, I can't speak on behalf of the landowner, but my conclusion might be that they knew they hadn't done very much with the site at all, hadn't engaged any assessment feasibility work of the site until some time after the council had taken a decision to promote this CPO. We had been told on several occasions that they were just about to undertake feasibility work, but that never came forward to my knowledge, and certainly we've had no sight of any feasibility work having been undertaken.
Mm-hmm. The one thing the council consistently don't want to mention, what's the relevance of COVID lockdown? Do we just ignore the fact that there was a lockdown period and all the impact on business life during that period and the various restrictions thereafter?
I think there's obviously some relevance, but certainly I don't think it would have hindered a landowner undertaking feasibility work. I understand it had, and I agree with Mr. Stewart's conclusion that the slow down development, certainly in the private sector, particularly around the particular lockdown periods during COVID, and obviously the last year have been challenging in terms of construction inflation, but nothing really would have prevented a landowner undertaking feasibility work, submitting planning applications and so on. All that still went on. Certainly from our point of view, we're delivering a £50 million programme of development activity, and we were still engaged with consultants, planning, site investigations, the whole gamut of what has to happen to enable development to happen. But yes, we also, did, have to deal with tenants during COVID as well. So yeah, our attention was diverted somewhat, but it wasn't something which absolutely hindered our ability to continue with development proposals and preparing feasibility work.
And then, for the sake of completeness, the list of steps ceases with 9 September 2022, the pre-application meeting between the landowner and the council. that obviously postdated the compulsory purchase order, but predated just the objection. You would accept, given that the landowner has objected to the CPO, it would be inappropriate for the landowner to advance proposals pending the outcome of the CPO process.
Yes, I think I can understand the reasoning for that.
And going back to your precognition, at 414, first paragraph, you refer to various issues that have been touched on already. What I wanted to pick up with you is the second paragraph. You say the landowner has made it clear in its statement of case that its preference is to seek planning permission for a retail development. Going back to the objection, 5.5, the objection says retail is only one of the options being considered by the landowner. That's not indicating a preference to seek planning permission for a retail development, is it?
Not in that section, no.
The point I want to put to you is the council seem to have decided that the landowner wants retail and nothing else. And I'm not entirely clear what grounds the council are putting forward for having reached that view.
Certainly, my understanding is that the pre-application for retail certainly gave a very strong indication that the preference was for retail use.
You say your understanding. Did you actually read it in detail, or did someone tell you that?
The pre-application.
Well, you've just said your understanding. I want to know, yes, where did you obtain that understanding from?
Yes, I've read the pre-application consultation.
Right, and that's what you're basing that opinion on?
Yes.
The objection postdates that pre-application consultation. You've ignored the objection.
Well, certainly that is my understanding, that the landowner, his preference is to secure retail for the site, and has been historically.
It's not your understanding anymore, because I've just told you that it doesn't take into account the objection that was submitted to the council. So it can't be your understanding anymore. So the reporters should note that your understanding as expressed in the precognition is wrong, shouldn't they?
Well, yeah, that's certainly my understanding might well be incorrect on that basis then.
Well, I'm sure this will be explored in some detail with Mr. Stewart, because it does seem to be a very key plank of the council's case. And some frustration at my side, as it were, with the misunderstanding there. Going back to your precognition, 415, you say there are no alternative sites which are available nor suitable for purchase. Now, it's not very clear what your area of search is. Is there a document that the reporters can go to which identifies clearly your area of search?
The area of search relates to Hill End and Donnybristle Industrial Estate.
That wasn't the question, or the question was where is there a document that makes that clear?
Well, there isn't a document which demonstrates the search that I've undertaken, but it is from my own knowledge of the lack of available sites in the area. And also, I reference to the Fife Employment Land Audit, which, whilst it identifies sites which are allocated, I know from my own personal awareness of those sites that they're not available or have been purchased or are under occupation by businesses.
And the statement of reasons does not refer at all to the Employment Land Audit. There was reference earlier today to 3 housing sites. The reporter took an earlier witness to the relevant part of the local development plan, and just to make the exercise a bit easier, if we focus on the Muir Homes site, as things stand at the moment, that is not developed, is it?
No.
So in that sense, it is available, isn't it?
But it is an allocated housing site. So it's not available for employment use, because that would be contrary to the Fife plan.
That is something that would need to be considered. So your evidence is that you have only taken into account allocated sites allocated for employment use.
Yes.
But you would accept, at least in theory, the council could CPO the Muir Homes site and take it back into employment use. And I think we heard previously it was part of the estate in employment use.
It was, but it is currently allocated for housing purposes. So,
but we have heard from Mrs. Stewart that it's now on to the 4th application, and there appear to be serious difficulties obtaining an acceptable access and also protecting residential occupiers from noise problems.
that's correct. I don't know the detail of that application, but I understand it is still a live application now. So it's still under consideration. So I don't know whether that will get planning permission or not get planning permission, but certainly historically that is the case.
Mm-hmm. But in terms of the site search you did, the consideration you gave to the site was really nothing more than it's allocated for housing, therefore it falls out of your search.
Correct, yes.
And the final point in relation to demand, in your precognition paragraph 4.2, 4.3, 4.4, 4.5, 4.6, 4.7, 4.8 and 4.9, the examples you've given there, those are all examples of demand being met on existing sites.
That's correct, yes.
So you've not mentioned any actual demand to use the CPO site.
Well, really gets back to my point, the site is not actively marketed for employment use. So I don't know how anybody could demonstrate there's actual demand for that site. And it also, you know, I would agree with Mr. Riley's comment that what we're demonstrating here is that there's active demand in the local area. And again, I think it's a reasonable conclusion to assume that that demand would also be available for the CPO land and still be relevant for the CPO land. But I can't prove actual demand for a site which is not actively marketed by the landowner.
Well, why not? Because surely if users are interested in a particular area, which seemed to be Mr. Riley's point about the Southwest Wedge, surely it is something that is feasible is to prepare a list of people who have expressed interest, and if the council thought the site had prospects, what's to stop the council reaching out to people they know are interested to say, would you be interested in this site if it was available? It sounds like you've just assumed it's not possible to provide any evidence and not actually tried.
Well, we know the landowner is not willing to engage in relation to the sale of the site. So we're not going to undertake an exercise to find out or try to market the site on behalf of the landowner to prove or disprove there's a demand or not for that site. We've acquired 24 Ridgeway. We've marketed that for a period of 6 or 7 months, and we now have a preferred bidder for that, with whom we've agreed terms. We had a total of 15 inquiries, a number of serious inquiries within that. We selected the preferred bidder based on their ability to demonstrate how they would meet our aspirations under the Edinburgh and South East Scotland City deal. And we know that there are other users, businesses in the market actively looking for land. But we can't really direct them to a landowner who we know is not willing to sell that land.
I think, though, you're misunderstanding my point. I'm not suggesting you direct them to the landowner. I'm suggesting you say to them, if the site was available, would you be interested?
I see what you're saying. It'd be a fairly academic exercise, I think.
Well, show potential interest in the site.
Yeah, I'm not sure what premise we would have to go to speak to various businesses and how we would identify those particular businesses in the first place to find out if they were interested in that site.
You just told me you selected a preferred bidder for one site based on, I think it was 15 serious interest. So that leaves 14 that you could have gone back to and said, we're not sure whether or not this site might be available, but if it is, would you be interested? But you haven't done that.
No, we haven't done that, but on the basis that we would not want to waste anyone's time if we know that the landowner is not willing to sell the land for employment use.
The council are proposing to CPO it. That would make it available. That's the whole point of the CPO. So why is the landowner's position at the moment got anything to do with whether or not the council would find out about interest from the market?
Mm-hmm. Well, we haven't done that exercise, and again, I'm not sure what premise we would have to go to speak to potential buyers of a site that we don't have control, and give the length of time and the process that has to be gone through in terms of the CPO. There's no certainty as to the outcome of that process.
Mm-hmm. But for the site to be of interest to potential occupiers, the evidence seems to be it needs quite a bit of money spent on it, servicing, etc., etc. So even if we were having this discussion after the council had acquired it, there would still be a substantial amount of time before you would be able to actively market it. So I don't see why it makes any difference at all the landowner's position. Surely it's a situation where landowners and developers frequently make inquiries with potentially interested users to establish the level of interest to decide whether or not they might move forward to the next stage, whatever that next stage might be.
Yeah, I mean, I take the point you're making, and it would be some time before we were able to remediate the site. You know, that all does take time before we could make it available to the marketplace. But we'd be confident, as I say, based on our experience. That's all I was setting out within my recognition, based on our experience of sites and premises that we've been involved with. There has demonstrated a good level of demand for those sites and premises. And again, logical conclusion would be that that would equally apply to the site once it has been remediated and serviced.
Which could be several years from now, by which time market conditions could have changed considerably.
Yeah, I don't know if it needs to be several years from now, but it could be a period of time, certainly, before we've remediated the site and serviced the site. I don't think it would necessarily have to be years, but markets, you're right, markets do fluctuate periodically, but in the long term, we're confident that there is a good demand for the site. And I think, you know, based on Mr. Riley's evidence and my own knowledge from other sites that I've been involved with, certainly the council's intervention has been extremely useful in bringing forward sites which otherwise wouldn't be brought forward for development.
And one final point, and apologies, I missed it on the way through, so it's another bit of jumping out. Recognition, paragraph 412 that we were looking at. It starts, the CPO land is in a particularly prominent location within the industrial estate and is the first vacant site which anyone entering the estate from the main western gateway will notice. We've been through that. You go on, it provides a poor image of the estate, not only to any existing business occupier, but also to any visitor or prospective inward investor. This poor image of the estate, that's not mentioned anywhere in the statement of reasons, is it?
Maybe not specifically, no. I would need to look back at the statement of reasons, but I think, you know, it's fairly self-evident that it does provide a poor image to the estate, and, you know, through the council's proposals, it would remove that impression that potential investors have of the overall estate.
Well, I'm sure you can see the point I'm making, that self-evident or not, if it's supposed to be one of the reasons for the compulsory purchase, it's reasonable to expect it to be mentioned within the statement of reasons. It's not. So the inevitable conclusion is either it's an afterthought or it's just not that important.
Well, I'm not sure it's an afterthought, but the statement of reasons does refer to the fact that the site is on the vacant and derelict land register and has been for 20 years. And the purpose of the vacant land register is to identify sites which are in a poor state of repair and condition, and by the fact it's on the vacant and derelict land register must indicate that it's in a derelict condition and is vacant.
There's a difference between derelict and presenting a poor image of the estate?
Well, I think if something's derelict, it probably presents a poor image. That would be my conclusion from that.
Mm-hmm. Well, I think that's about as far as we can take that. Thank you very much, Mr. Hare. That was all the questions I had.
Okay, thank you. I've got a few questions. If I go slowly, it's because I've been scribbling so much down, and I just want to make sure I've not lost the sense of some of the questions that I'm saying wrong now. And like this, probably we go be different themes or different documents. I wanted to start with looking at the purpose again. I know there's been a bit of discussion on that. This isn't a direct lift from a document, but my general impression from across different documents that the council's provided to the inquiry is that there's a couple of broad, commonly occurring lines of argument in terms of why you want to do the CPO. And the one is that the site's long-standing vacant and derelict site, and that might have attendant amenity benefits. And secondly, you believe the site is required for, or there would be demand for the site for employment use. And in paragraph 2.2 of your recognition, you say the evidence I shall present relates to the justification of the council scheme with particular relevance to the requirement to purchase the subject site to support the regeneration of Hill End and Donnybristle industrial estate, and to ensure that the subject site is brought back into beneficial use for employment land. And it might just be the way I'm reading it, but that reads to me as though the key requirement in terms of you can pin why do you think the land's required? You definitely think the land is required to facilitate regeneration. And I think that for me chimes with something that you said to Mr. Collar earlier, in that you said, I think something along the lines of it's self-evident that something needs to happen to the site, and you've been keen to see something happen to the site over time. In terms of identifying whether the market demand, I guess we've mostly talked about so far, the market demand for employment use in the area equates to a requirement. I think that's where maybe more of the conversation has gone around a bit. So do you see it as the reason that it needs to be done, it requires to be done, is principally around that broader aim of regeneration and improving the amenity, removing the amenity disbenefit? Or do you also genuinely believe for that site there is an evidenceable requirement for the scheme that you're actually the scheme you're proposing?
Yes, I think it is both. There is a requirement to do something with the site and to remove the disamenity and the impact it has on the estate, the businesses, the local residents. But there's also a very positive requirement to deliver employment land, a positive requirement to see development on that land. And that development will create employment for local people and support, and that's certainly our aim, is to secure high value, high skilled jobs for the site. And the proposals are being funded, as I said before, by the Edinburgh and South East Scotland City deal, which has got a specific focus on innovation and growth. And those would be the criteria by which we would judge and assess any requirement, just exactly as we've done for the site at 24 Ridgeway. So just to put that in context, the developer there is intending to build a manufacturing facility of around about 35,000 square feet. And we'd like to see something similar happening on this site to create high value, high skilled employment for the area, which is entirely consistent with Hill End and Donnybristle's long history and track record of attracting large businesses into the estate. So it's part and parcel of the whole estate regeneration. And at the same time, it will remove the site from the vacant and derelict land register and remove all these issues which go along with it.
Is there, between removing it from the vacant and derelict land register and the attendant issues for that, between that and getting a employment use of the type we describe onto the site, is one of those the sort of lead motivation, or are they equal?
It's maybe difficult to assess the difference. I think our focus always, from an economic development point of view, is employment, job numbers, and good quality employment. But this is part of a very long programme of regeneration activity. So I think the two go hand in hand, if I'm honest. And I think it might be difficult to say which one takes priority over the other. But I think the estate regeneration will help generate and secure and retain the existing employment that's already there in the industrial estate. So that's the other aspect of this, is ensuring that we retain and we don't lose employment as we have done in the past in some estates, and including this estate, to other locations.
Okay, thank you very much. You mentioned the long-standing vacancy of the site, and I can see, because a lot of the documents that the council submitted are quite long-standing documents. One of those is the Yellow Book document that Mr. Collar already mentioned. I think that's one that's around 10 years old. Mr. Collar had a conversation with you at the beginning of his cross-examination about the action plan that's submitted as part of that document. And there was a conversation around monitoring the implementation of the action plan, and getting on with delivery. Something I noticed in the action plan was that although Beech Way, there is an action, and it's an economic development action in there, which is to pursue progressive redevelopment of Beech Way. There's not a suggestion in there that would extend to the council acquiring land. And the reason that sort of jumped out to me was that for quite a lot of the other sites in the action plan, there were specific references to council acquiring land. I think there were, Burnt Island, Hardenden, Bowhill, Coopard, and Fernling, Glenrothes, leaving out Lochgelly and the West Five Villages. All of those sites had acquisition down as a specific action, and the CPO land didn't. So the fact that CPO, I know it was 10 years ago, so time has moved on, but now that it has come forward as an acquisition site, rather that being something that's implementing the action plan, is that a sort of change of tack because of something that has or hasn't happened in the intervening time?
Yeah, I think, just to give it a bit of context, the council, I think it was the Policy and Resources Committee back in 2012, did approve the promotion of a CPO of the site. Following that, the then owner carried out the demolition of the vacant and derelict buildings in the site and cleared the site, and had given us assurance that something positive was going to come forward for the redevelopment of the site. So that was over 11 years ago now, or around about 11 years ago. And we have, as I said, had a long history of engagement with the previous and the current owners, seeking to bring forward the site for some development, not necessarily the council acquiring the site, but it's only really become apparent, over time that nothing has happened on the site, and we feel that the time has come that the council has to intervene, otherwise there is a risk that the site just lies vacant and derelict in its current condition indefinitely. So it's really a matter of last resort. We feel that concluded that we had to promote the CPO, and we've clearly been investing a lot of time and resource into other sites within the industrial estate, notably West Way, with secured funding through Scottish Government economic stimulus monies, and we've secured funding through the Edinburgh South East Scotland City deal to deliver 2 phases of new build industrial development at West Way. We've undertaken the acquisition of 24 Ridgeway. We've concluded missions to sell former skate park site at Ridgeway to a speculative developer who's going to build 10,000 square feet of new build industrial units. And really, this is one of the, not last necessarily, but next priorities that we feel that we have to take some action on.
Okay, and in terms of the timing of that decision and that action, maybe you don't need to find the right note. I might regret that in a minute. You mentioned that there had been a previous decision to make a CPO in 2012, and that decision wasn't, that CPO wasn't made eventually. And I've got a timeline of things I picked out from some of the submissions. So that's mentioned their approval to promote a CPO in 2012, but then the next year, 2013, the previous owners demolished buildings and intimated that they had an intention to redevelop. And then there's a bit of a gap of a few years. Obviously we know that they didn't develop the site, but also I don't know that anything else, anything or what else was happening and that in that time. And then several years later, Fife Plan came along. A bit later again, the current landowners bought the site. So there was a bit of a lag there between the council deciding to have a CPO, then not taking that forward, nothing happening, but still that opportunity to make a CPO not being sort of realised last time around. This time around, the timings I've got noted down. So the council got the approval to make the CPO in August last year, and then it made the CPO on the 16th of August this year. And the date in my timeline, what jumps out to me is that it's the day after the pre-application inquiry came in. So I know Ms. Stewart gave Mr. Warren a really clear answer yesterday when he asked, was that a trigger, a reason for the CPO? And she said no. But just in terms of understanding why the decision, why the urgency to actually go ahead and make the CPO when you made it, what happened to galvanise you around that date? And did you know that the pre-app for the retail was coming in, even if that wasn't a final trigger?
Yeah, I don't think the pre-app was the trigger for the CPO. This is a long-standing objective of the council to acquire the site. So the pre-app on its own would not have been the trigger for that decision. It was a decision taken by elected members at Cabinet to promote the CPO, and we've always had the intention to acquire it, and we'd rather buy it by voluntary agreement, but that was evident that wasn't going to happen. So really the decision was taken that we had to promote CPO in order to acquire it.
You mentioned there the council decision, but that's the decision from last August, isn't it? Well, previous August was the decision to grant authority to make a CPO. Yeah. Then the CPO actually being made, that happened on the 16th of August last year. So how was it decided that was the day to make?
I don't think there was any.
How did that come about on that day?
I don't recall any specific decision taken about the particular day the CPO was made, but we would have secured a business case approval through what's known as our Fife Industrial Innovation Investment Programme Board to proceed with the promotion of the compulsory purchase order on the basis that we'd tried on several occasions to engage with the landowner to avoid the CPO, to enable us to buy it by voluntary agreement. But that was apparently that was not going to happen, and therefore we decided we had to proceed with the CPO process.
Okay, and did the person or the team who actually made and sealed, sorry, whatever the proper terminology is, the CPO, know from the planning team that a pre-application inquiry relating to possible development of the site had come in the previous day?
I can't recall that. It may well have been that it had been discussed, but I'm not sure that planning would have notified that programme board of that proposal.
The pre-app did come in, and you've seen that since and still pursuing the order. That doesn't change your mind at all in terms of whether you need to pursue the order. At this time, you still feel the argument is there, like that change in circumstance.
Yeah, no, our position hasn't changed in that respect. The council is still committed to securing the purchase and the site servicing works under the Edinburgh and South East Scotland City Deal programme. That hasn't changed at all. No.
Okay. I'm just going to look back at my notes a second. I want to look a bit at the evidence base on how much employment land is required, because I'm finding it quite hard so far to nail down when people in general are talking about there being not enough employment land or a shortfall of employment land. I'm trying to look and equate that to some figures or targets that are set down somewhere, whether that's in the development plan or somewhere else. From the conversation today so far with yourself and with Mr. Riley, it sounds more like the up-to-date view on demand or requirement is based around current understandings, current experience of market demand. But the 7-year supply, the concept of a 7-year supply of employment land, which is mentioned in LDP Policy 5, I'm keen to properly understand where that comes from and whether it's still something that's relevant.
I think that is referred to within the Fife Employment Land Strategy under Chapter 6 and the calculation of employment land.
That's where I've seen it.
And in that, it refers to the demand is based on take-up patterns, inquiries made by council for employment land and property, patterns of employment within use classes 4, 5 and 6 across 20 key settlements and location of Fife's top 100 businesses.
Yes. And so it's from consideration of all that, that's where the figure of 2 hectares for Duggetty Bay comes from.
Where that would have come from, yeah.
That's where that would have come from. And similarly, because of all the consideration of that, that's why there's that general land requirement. There isn't a strategic land requirement that some other settlements have. The outcome of that work to me seemed to be twofold. One is the 2 hectares general requirement and safeguard the land that you've got already.
That's correct, yes.
Yeah. So the safeguarding the land you've got already, can see how that's enshrined in the development plan, because that's the key purpose of Policy 5. In terms of the 2 hectares, how was that envisaged to be supported by the development plan?
I think through the allocation of sites within the
Okay.
development plan.
And those sites, I haven't got the figure to hand, but I think those 4 employment sites that were allocated did amount to more than 2 hectares. Tell me if I'm wrong. Don't have that written down in front of me. But my next question on that is, so the 2 hectares, the LDP did what it could to address that by allocating land up to and potentially beyond that figure. So has that 7-year employment land supply not been dealt with and that's complete now? Or is that still a live requirement and a live concept?
That is still live. That's still currently part of the Fife Employment Land Strategy.
And the employment land strategy, though, so my understanding of what the relevant 7-year period for that 2 hectares is, would be that it would correspond with the 7 years that that strategy covers, which it's 2014 to 2021, if I'm right. So am I right to deduce that was an employment land strategy for those 7 years? It set a 2 hectare 7-year employment land supply. Was that the land supply for those 7 years?
That would be the case, I think, yes.
So now that we're in 2023 and we're beyond the intended timescale of that plan, is there somewhere else that you or I or anybody can look to see that was the requirement for those 7 years? What is it now?
That is something that we're currently working on. It's a revised Fife Employment Land Strategy. So that has not yet been concluded or published.
Okay. So what would the council be doing in the interim with that gap? It seems there's in terms of a continuation of that approach and rolling forward of that approach in the gap period that we're in now. What's the best way of dealing with that?
Well, we still apply the current policy under that's our current strategy, the Fife Employment Land Strategy that currently stands.
So the 2 hectares is still the 2 hectares?
Yes.
The LDP dealt with those 2 hectares. So is there not at the moment, whenever we're talking about a shortfall, just so I'm clear, is that always talking about a shortfall when read against market demand, or has there been now a shortfall in the 2 hectares? Were the sites that were meant to deliver that 2 hectares, did they not happen, or did they happen?
Not. I'm maybe not best placed to comment in detail on the actual calculation of that amount, but I do know that the allocated sites, have been reviewed, and certainly from my knowledge, the sites, say for instance, the Ferris Way site DGB 005 is not effective because it's under an occupational lease. Similarly, 006 Fulmer Way is under occupation by Grant Construction. 007 is part of the Western Gateway development, and that is now a mixed use proposal. The employment provision has been provided by virtue of the Class 6 element within that building, and I believe that there's a cost of coffee or similar to happen on the remainder of the site. And then the site GB 008 Muirton Way has been acquired by a company who are proposing to build a factory on that site. But I've got no reason to say that the requirement for 2 hectares is any less than it was. And I think, based on the demand that I've encountered in marketing the site at Ridgeway, that could well be an under-representation of the real level of demand that might be there in the market.
So if we're working to the 2 hectares and the CPO site was brought into the land supply,
Yeah.
What would the land supply be then?
I might have to defer to Mr. McMenemy and his evidence.
Okay.
The detail of the calculation of that.
Yeah. I'm asking this partly out of interest, just trying to piece that picture of how the different ways of measuring the land supply or demand work together, but also if it was, if it was clearly the case that now there's a demand, an identifiable requirement for 2 hectares, I'm interested to know, would the site take you up to or beyond the 2 hectares? So if that is something that Chris is able to answer when he gives his evidence, Mr. McMenemy, that would be helpful. But I'll leave that there now and just check if there's any other areas. I think that is everything for me. So I'll stop my questions there. Mr. Warren, have you got any questions?
Thank you. Yeah, it's just it's a kind of a follow-on question from one of the questions I asked Mr. Riley about the kind of relevant geography in terms of understanding current supply and demand for employment land. Now, I appreciate that there's a 2 hectare figure that we've just talked about in terms of Dalgety Bay. Mr. Riley said that in his view that Southwest Fife was the sort of relevant geography in terms of kind of thinking about supply and how that's met. What's your view in terms of those 2 kind of conflicting kind of positions? You've got the kind of figure around Dalgety Bay, but then you've got that wider question. And how does this site fit into that picture of kind of Southwest Fife more widely, as well as the question around Dalgety Bay itself?
Yeah, no, I would agree with Mr. Riley that this forms a key part of the wider bridgehead area, or the southwest wedge, as Mr. Riley referred to it as. So particular focus around the Betty Bay, Keating, Ferman, Rosyth, as being a very active economic area, just in terms of occupier requirements. We have very little employment land as a council in that area to deliver any potential investors. We recently acquired, or a couple of years ago at least, acquired a site at Fife Interchange North, which was a large site extended to around about 16 hectares gross, so 16 acres gross. It was nestled down to about 9, but it was largely unserviced. We carried out servicing of that, and we have now got an offer for about 5 acre site within that area, again for a manufacturing use. There are very few sites which are immediately available like that, which are ready to be developed by another investor. So whilst there may well be land in that wider area, that supply of that land is very limited in terms of immediately available and ready for development by an investor or developer. But yeah, certainly I would concur that the site is part of that kind of wider geography in terms of an employment supply provision. But Dalgety Bay, saying that, is a key settlement, and the Hill End and Donnybristle Industrial Estate does have its own identity in terms of a brand. As I said before, it is the base of a number of very significant large businesses which operate on a national and international basis. So therefore, I think it's right to look at Dalgety Bay in the context that it should have an adequate employment land supply, and what we're proposing to do fits in with that strategy of not only improving the employment land supply within Algetty Bay, Hillend and Donny-Bristol, but also that supply will contribute towards the wider supply within the southwest area.
Okay, thank you. And in terms of our understanding of what the supply situation is beyond Algetty Bay, would it be the employment land audit that would be the kind of principal source of information for that?
Yeah.
So my understanding, we haven't actually got the employment land audits before us, but my understanding is that this site hasn't been identified in the employment land audit because the audit focuses on particular types of land, so allocated sites or sites with an active planning permission place, in which this doesn't satisfy either of those criteria. Is there a possibility or a probability that across Southwest Fife there are other sites that kind of fall between the gaps and are not being counted by the employment land audit, but could contribute to that supply?
I suspect that might be the case, but I couldn't give a definitive answer on it. And again, it might be something which Mr. McMenemy, as part of his role in relation to the Fife employment land audit, might be able to answer.
That's fine. Yeah, I don't want to miss my opportunity to ask. If I have to ask a question twice, that's fine. I think it's probably just one final question, which perhaps I haven't quite covered enough. So, Mr. Kohler asked you about kind of the activity that the landowner has undertaken, and he took you to the objection and the list of kind of steps that have been taken. So my question, I suppose, is kind of what action would you have needed to have seen from the current landowner for the council to have not taken the CPO forward at this time?
Well, I think active steps to market the site would have been very helpful, and I think really that is essential when you're trying to sell land, or if you've got a serious intention to see it develop for its designated use. You do have to actively market the site. So, as I say, there's no evidence that the site has been marketed on all the normal commercial websites, as mentioned, Novaloka, CoStar, Link, or even the web agent's website. So that would have demonstrated at least there was a genuine attempt to seek a buyer for the site. I also think taking up the point about the need or the preference to undertake site remediation would have been something which could have happened over that period of time to make sure that any significant constraints to development were removed. I think that would have been a very positive step forward. Dealing with some of the general maintenance issues on site, broken fences, walls, overgrown vegetation, etc. That could have been addressed to make the site at least not as much of a disamenity to the wider estate. I think, from our point of view, active steps to seek a buyer for the site in accordance with its planning destination, I think would have been probably a very positive step forward.
So on that point, why is marketing critical? I mean, is it conceivable that the landowner might want to develop it themselves and they've shown you that they have intention of doing so? I'm just wondering whether is the sort of disposal of the site critical, or is it seeing it being developed as critical?
I think it's seeing it being developed is critical, and from our point of view, within an employment use context.
Okay. we're going. Yeah, so we're going back to Mr. Swift Adams. So that's all my questions. Thank you. But I'll just hand it to you. Thank you.
Yeah, sorry. Part of that questioning from Mr. Warren's just triggered another question. I had a note down on something that's in document FC11. That's that site employment land strategy that we've been talking about. In paragraph 7.2 of that document, part of that paragraph says Dalgety Bay does not require additional land supply and priority is given to protecting the existing supply. And what that makes me wonder is, I mean, so I know there is 2 hectares. General land requirement came from there, so I'm assuming this refers more to land beyond that or land to the strategic supply. But I just wanted to check. So when that view is taken, we don't need additional land. We need these 2 hectares. At that point, was the CPO land being counted as part of the established land supply, or wasn't? So was that decision that no more land was needed based on an understanding of the amount of land already in the supply, including the CPO land, or excluding it?
I'm not sure what the position would have been in 2014, but I suspect if it was designated as safeguarded employment land, it didn't actually contribute towards the supply as an allocated site.
It was part of the land that was available but needed to be safeguarded.
Yes.
Right, established but needing to be safeguarded.
That's right, yes.
Yeah. Available and meaning. Okay. And in terms of how the employment land audit, in the terms Mr. Warren described, monitors the land, and the land that it doesn't monitor, and it wouldn't count towards the 7-year housing land supply. Because that CPO land is part of the established land supply and has been all that time since the employment land study was created. Does that mean that in terms of, even if it's just as a technicality, as a technical monitoring instrument, if this CPO went ahead and the land came into the council's ownership and the council took forward the proposed scheme, in terms of how that would affect the monitoring of the land supply against that requirement that is looked at in the audit, would that not make any difference? So the 2 hectares now, the 2 hectares is there, it's intended to be safeguarded land, it's never intended to be part of the 2 hectares general land requirement. And because even with the CPO scheme, it wouldn't be an allocated site and it wouldn't have planning permission, would it still not technically count towards the 2 hectares?
My understanding, it would still be a safeguarded site, but I think, again, I would have to defer to Mr. McMenemy, who oversees the monitoring of the employment land audit in terms of the technical aspects of whether that would actually contribute towards the employment land supply. But my understanding is that as a safeguarded site, it would remain as a safeguarded site. It would not technically contribute towards the employment land supply.
Okay. Thank you. That's my last question. Promise. So, Mr. Devlin, do you want to ask any more questions of your witness?
Thank you, ma'am. So here, could you please to document FC05, which is Fife Council's response to the objection made by the management. Specifically, the conclusion in that document.
The response to the objection.
This is the Fife Council's response to the objection. The final paragraph of the conclusion states the council will not withdraw the CPO or agree to assist the CPO procedure at this time. Should the landowner submit a planning application for development which falls within the current allocated, I suspect that might be safeguarded use in terms of Fife plan, along with a commitment to develop the CPO land, the council will reconsider its position. And following on from the conversation that you had earlier with reporter Laura, what's your view in respect of that statement as at today?
Yeah, I think we stand by that, and we have made an offer to the landowner that we would agree to assist the CPO process should the landowner come forward with an employment land proposal, and give a commitment that would be followed through in terms of delivering an employment use on the site.
Thank you. I don't have any further questions, ma'am.
Okay, thank you very much. We said we would break for the day by 4:30. I think half an hour is probably quite tight to aim to get through another witness. So I would suggest that we break now for today and resume with Mr. McMenemy tomorrow. Would people be happy with that?
Yes, thank you, ma'am. That's fine from the council's perspective.
Okay, and the objector happy with that?
Yes, madam.
Okay, I say that partly because having completed 3 witnesses today, there's 2 more, so I'm still fairly happy we'll be able to get through those tomorrow. I said earlier on we'd resume at 9:30 tomorrow. I don't think I saw any objections to that. So is 9:30 achievable for everybody tomorrow that needs to be here?
Yes, thank you, ma'am. That's fine as well.
Okay. So unless there's any questions before we close for the day, and I'm not sensing any, I'll close the session for today and see you again at 9:30 in the morning when we'll start with Mr. McMenemy. Okay, thanks very much. Thank you.
Thank you.